Good morning, everybody.
Good morning, Your Honor.
County Superior Court is now in session. Please be seated.
Good morning. Now before the court is Hampshire County Civil Action 1780 CV 0033, Patrick Buchanan et al. Versus the Town of Greenfield et al. Scheduled for the resumption of a jury trial.
All right, good morning. Just bear with me a moment while I get set up here. Melissa. No, definitely not. All right, I've got a number of matters that council have filed that require some consideration, some other matters. First, I believe, indeed, that it is the juror who was in seat number 6, juror number 43, phoned in last Thursday, indicating that he had tested positive, and so he's been excused. So that leaves us with 1, 2, 3, 4, 5, 6, which is what we need. Hopefully, are they all here?
They are here.
Okay. So, great. Thank you. Appreciate that. Now, okay, the renewed motion for directed verdict I'm taking under advisement. Okay, there was some argument in that regard that spanned the past day or two of trial. That would be taken under advisement. The second motion for mistrial. Mindful that we've got jurors who are waiting, and I do wish to move us forward. Trinity Keston, I'll hear from you.
Primarily, Your Honor, there's a couple of things in this case that cannot be unrung. The flag, Confederate flag, and questions about the Confederate flag, and questions about other officers about the Confederate flag, and questions about the fact that the Confederate flag was an issue in the town of Greenfield. Have been allowed to evidence. As of this moment, the jury still believes that the Confederate flag is a part of the case. Second, it really goes down with Todd Dodge's claim. Lieutenant Dodge's claim is dead, and yet he has been allowed to testify that, in his view, he took the chief's comment as being racial, which should never have gone into evidence. In light of all this, we do not see how the jury could possibly render a fair verdict.
All right, thank you. Who wishes to be heard first?
The Todd Dodge information is completely outside the scope of this motion, and we just think the court should reject this motion. This is, I think, the 5th time counsel's asked for a mistrial. It's been a fair trial. We should go forward to the jury.
Okay.
Your Honor, we're here at the 11th hour, and I guess the only thing I joined my brother in, I don't see how the court takes the Confederate flag out, having allowed it in, and that's subject of our own motion. But because of the prejudicial impact it will have on the plaintiff, Pat Buchanan.
Okay, thank you. One moment, please. All right, the motion is denied. I find that there is no error, let alone grievous error. And when we talk about the proposed track changes to the jury instructions, you'll hear that I am going to make some modifications to the jury charge as it relates to the Confederate flag. Those modifications will satisfy any concern that is raised relative to the introduction of evidence relative to the Confederate flag during the course of the jury trial. So that's the motion for mistrial. Melissa? All right, next. The chalk. There was an objection to the chalk going in. Bear with me a brief moment. One moment, please. Okay. The chalk is going to go to the jury, and it's going to go to the jury with the following charge that I will add to the jury instructions. A, for identification, I believe it was. Or words to this effect, is an illustration. It is the party's description to describe something involved in this trial. If your recollection of the evidence differs from the chalk, then rely on your recollection. And counsel are free to argue the weight of the chalk during your closing arguments. So that's going in on the chalk.
Is it going as an exhibit?
No.
As a chalk.
As a chalk. And you are free to argue that it's worth nothing.
And it's going into the jury room.
Correct. As a chalk. Okay. As is permissive. Next, there was this entire. There was a question that Attorney Keston raised about whether or not I was going to allow the written grievance to go in as part of the whistleblower claim, I
don't see that as, the grievance, I thought it was an agreed to exhibit.
It is.
Yeah.
Okay. Well, then I guess that request is withdrawn, so that takes care of that. Then I've got the plaintiff's motion, consolidated motion for relief. On the Confederate flag issue, I'm not going to reconsider my ruling, which when for the first time there was argument relative to the Mole case and the effect of a intervening thorough investigation on attributive bias when I indicated that I was not going to permit evidence of the Confederate flag to go in. So there's nothing different in that regard. So it's going to go in. However, I am going to instruct the jury in particular, and here I'll just make a brief diversion to the defendant's proposed track changes. Instead of what I had initially, which was that I instruct you to disregard evidence relating to the Confederate flag on Sergeant McCarthy's premises, you're not to consider in any matter. I'm going to allow in just a part of what the defendant had requested. I've allowed you to hear evidence that at one point in time a Confederate battle flag was hanging in a garage partially owned by then Greenfield Police Sergeant Daniel McCarthy. I have since reconsidered my ruling and have determined that testimony as to it, I guess, is not relevant and should not have any effect on any of the findings you were being asked to make in this case. So that's how I'm going to deal with the Confederate flag issue. Then I've got the issue of the special jury verdict. And what I'm going to do here, the plaintiffs The plaintiffs have indicated that at least the constituent parts of questions 1, 2, and 3, I believe, were at issue, are not so much objectionable as much as the exclusion of their request for an overarching question. So I'm going to ask all of them. And in that regard, one moment, please. Right. Evidently, this is sitting on my desk. No, let me go get it. One moment. Okay. All right. What the special verdict slip is going to provide is the first question that plaintiff was requesting that related to whether or not there was discrimination based upon race during a period of time from 2014 to 2015. And then I'm going to say if your answer is yes, then go to the following questions, okay? I don't think that that's going to give us an inconsistent verdict, okay? But that is what I'm going to do. I'm going to delete the words so-called. Counsel can argue that. So you'll see the special verdict slip. All these things are being actually revised as I speak, and that's what I'm doing on the special verdict slip. Now, defendants proposed track changes, which I do greatly appreciate. I'm incorporating some of them, but not all of them. This is what I'm doing. I've already told you what I'm doing on the Confederate flag issue. Everything else there I'm not doing. I'm including an instruction on chalks at the end of the evidence section. Then here's some minor typos, which I appreciate. Those I'll put in. I will correct that as to say. Page 13, direct evidence. There was struck testimony of a witness describing what his state of mind was. I think that was probably struck because there was maybe no evidence in that regard, and so I've struck it. On that same page, the burden of proof rests with Mr. Buchanan at all times as opposed to the burden of persuasion. Thank you. Yeah, I don't know why you want this in. Under unexamined bias, which is at page 14, I'm thinking of just leaving what I have, and candidly, I'm not sure why, how what defendant has added advances their claims. But are you requesting that I add in statements made by the defendants as reflecting stereotypical thinking, categorizing people on the basis of broad generalizations, when considered with other evidence of disparate or unfair treatment, may lend support to the contention that an adverse employment action was made on an impermissible basis? You're asking me to add that?
The problem with the instruction as is, it seems to indicate that the statements, stereotypical thinking, that this that you can have animus simply because, without the person knowing it, that they can win. That animus can be established. It talks about statements and other things.
Oh, yeah, and
the problem is if you can't, if it's just that, you cannot. They cannot prove their case.
Okay, so the way you've got this is you want this added to what is already in the proposed language. Is there any objection?
No objection.
No, Your Honor.
I'll add it.
It just,
I know what it,
intermittent sites you might want to strike, but.
I got that part. Thank you very much. Okay, that's fine. One moment, please. Okay. Under mixed motive, I'm going to stay with the model. So that's what I'm doing. You can lodge your objections at the appropriate time, but I'm going to stick with the model instruction in that regard, which is what I had already given you. Then all this on back pay going, this is all argument. I'm not going to include any of it at page 21. Page 22, emotional distress, there was reference to expert testimony. That will come out. Reference to complainant, that'll be changed to plaintiff. Thank you very much. We now have 6 jurors, so there's not going to be any issue as to how many are going to deliberate. All 6 will, and 5 of the 6 must agree. And so at page 31 is reference to 10 of 12. That's got to be changed to 5 of 6. Okay. The audio recordings, thank you. That will go in. And so I do appreciate what you've done there. It was quite helpful. All right. I think that covers everything that I have. I've got someone actually working on these edits right now. And so I've just communicated those further edits to that individual. So we will have them. But I think that we can move forward to closing arguments.
I have a question.
Yes.
As to Mr. Lieutenant Dodge's claim. What?
Another directed verdict.
You know, Your Honor, as to Lieutenant Dodge's claim, I'm trying to figure out what to argue. The jury's supposed to decide whether or not he blew the whistle. Is it for them to decide whether the 3 events? So is that what I'm supposed to be arguing? That they need to decide it?
Well, I'm not going to tell any lawyer what to argue, for that would be inappropriate. However, you have the jury charge, which I'll be giving to this jury, and you are to shape your argument around the charge that I'll be giving. I'm not going to even suggest to anyone what they should say. What I will say is that any inappropriate, and this isn't directed at you at all, Attorney Caston, it's directed to all counsel, any inappropriate closing argument it may be the subject of an objection, which I will rule on from the bench. So I'm not going to comment any further on what you should or should not argue.
Okay. When I ask you the question, are you sending that question to the jury? Is that
Which,
the intent of your instruction? Is to send to the jury the question as to whether or not the grievances are blowing the whistle pursuant to statute? Is that something for them to decide?
okay.
It's not clear from your instruction that it is.
Your response, Attorney McDonough.
It's abundantly clear. We've been over this 10 times, Your Honor. We ask to proceed to closing argument.
Please give me something of a little more substance in response so that the record is clear as to what it is that you're seeking to go to the jury, because your argument has been consistently, then it is much more than just the grievance.
Yes. It's the refusal to participate in illegal activity. It's objecting through the grievance when unlawful discipline was imposed against this only black officer.
Okay.
It's following through every step for a year, from October 2014 through October 2015, objecting in writing, arguing at the arbitration and with the union that there was disparate, unfair treatment. It's all of these steps for over a year, Your Honor, and all three categories have been satisfied with the evidence and are properly within the charge.
Okay, thank you. All right, bear with me a brief moment. As I indicated, I'll be giving my closing argument instruction. You'll each have 45 minutes, and obviously Attorney Kessler will have 45 minutes for both his clients, and then the two of you will have to divide it up. Who's going to go first?
Your Honor, I will.
Okay. Is there something else you want to say?
Your Honor, what are we going to do with the masks? Do we have to wear them? Looking for direction.
I'll permit counsel to remove their masks during closing argument. However, we'll place the podium at a sufficient distance from the jury. So that being more than 6 feet for their comfort. Okay. All right. So what's going to happen is we'll bring them in now. We'll do our closing arguments, and then we're going to take a break while I gather the revised jury charge and special verdict slip, and then we'll bring them back in for the jury charge, which will probably take close to an hour and a half or so. Yes, Attorney Keston, I'm listening.
I would ask that you give the flag charge before the arguments, so that we don't have to tell them about the flag, but that you tell them ahead of time that you struck it, which is the normal course.
I'm happy to do that.
Thank you.
Okay. All right, very well. And to be clear, the reason why that came in is because, quite simply, the argument wasn't made. Okay. Or at least not in substance, as it was during the renewed motion for directed verdict. Okay, I'll see you all soon. Thank you.
Thank you, Your Honor.
Please.
Back, ladies and gentlemen.
Hampshire County Superior Court, it's now in session. Please be seated.
All right, well, it's been several days, so thank you very much, ladies and gentlemen, for all your understanding, your flexibility in our scheduling in this case. I do greatly appreciate it. You will note that we are down to 6 of you, and indeed, as you will hear from me a little later on this morning, in civil trials which we try in the Superior Court, we actually present them to juries of 6, and we select additional individuals as potential alternates. Okay, so we will be proceeding with the 6 of you, and I'll be commenting on that in much more detail after the closing arguments and after a recess. But first of all, I'll ask you, as I've asked before, has anything come to your attention which has affected your abilities to remain fair and to remain impartial? No affirmative responses. Okay, well, ladies and gentlemen, it's time to put down the pads and the pencils, for you're no longer permitted to take any notes as we commence the closing arguments of counsel and then my jury charge. And as I've indicated to you, at least preliminarily on the first day of trial, that you're going to have several copies of my jury charge with you during the course of your deliberations, so you'll be able to make reference to it. Well, ladies and gentlemen, you're about to hear the closing arguments of counsel, and this is an important part of the trial because it's the final opportunity that the lawyers have to address you. And it's an opportunity for the lawyers to summarize the evidence, to call to your attention certain parts of the evidence that they regard as important, and based on the evidence to try to persuade you to reach a certain result. However, what you're about to hear is not evidence, and that's because lawyers aren't witnesses. All the evidence in this case has been presented through the testimony of the witnesses and the exhibits, which you'll have an opportunity to examine and consider during the course of your deliberations. Our rules of court are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the attorneys are not permitted to refer to facts that are not in evidence in this case. And if based upon your memory and understanding of the evidence a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal belief in the credibility or lack of credibility of any witness who has testified in this case. That determination is for you and you alone to make. And if a lawyer makes such a comment, you should disregard that comment. This case must be decided solely on the basis of the admissible evidence and the law that I will be instructing you on. And attorneys are not permitted to persuade you either for or against either party by appealing to human passions or to prejudices. And if you become conscious of any such passion or prejudice as you consider the evidence or engage in your deliberations, then you must put those feelings aside and not permit them to influence your thinking. And if a lawyer makes any such comment, you should disregard that comment. Now, members of the jury, during the course of this trial, I permitted you to hear evidence that at one point in time a Confederate battle flag was hanging in a garage that was partially owned by Greenfield Police Sergeant Daniel McCarthy. I have since reconsidered my ruling in permitting that evidence to come in and have determined that evidence is not relevant to the issues in this case and should have no effect upon your deliberations. You are not to consider any such evidence in any manner whatsoever. Okay, now I'm going to turn over to Attorney Keston on behalf of the defendants. As I indicated preliminarily, when we present closing arguments, we switch the order from opening statements and we start off with the defendants. I've given each side 45 minutes for argument. I have permitted counsel to take off their masks, provided that they are standing at a appropriate distance from you, which I believe the podium is now set up, and they have done so. So we'll have 45 minutes for Attorney Keston. I'll give the lawyers a 5-minute warning and then a 1-minute warning so that we are kept on time. And thereafter, Attorney Ryan and Attorney McDonald will have 45 minutes, and they will have to share that between each other. Okay? So, understanding that, Attorney Keston.
Thank you, Your Honor. Good morning. First, on behalf of everyone here, Ms. Brody, Chief Haig, Mayor Wudegardner, the other, Mayor Martin, citizens of Greenfield, His Honor, I want to thank you. We want to thank you for persevering through this marathon of a case. We started out thinking it was going to be done in a couple of weeks, and you've persevered and stayed healthy. So thank you. You clearly paid a lot of attention to the evidence in this case. Anything that I tell you now is not evidence. If something that I suggest to you was in or out of evidence that is not, disregarded. I want to begin by asking you, I've been animated during this trial. You've heard the animation and the some of the exchanges in this trial. I ask you to please don't hold it against my clients. To the extent that you believe that I did something inappropriate, hold it against me, not my clients. You did not see any of the witnesses, the chief or anyone, do anything inappropriate. Don't hold it against me. But this case This case is a very passionate case. Imagine what it has been like for Chief Haig to come into this hot mess of a police department, featuring those two, in the fall of 2013, and tried to clean it up, and then to have him publicly accused of being a racist, of doing something because of Mr. Buchanan's race, or of initiating an internal affairs investigation against Lieutenant Dodge, who terrified a woman by releasing her name. But that was done somehow because he blew some kind of whistle. But imagine what it's like to be accused of something like that, have to live with it for 7 years, and now you will render a verdict. You will speak the truth. That's where the word comes from. You will speak the truth as to what happened here and why. And the mayor, the citizens of Greenfield, have faith that you will reach the right verdict. So let's look at what actually this case is about. As Anna has just told you, even though for 4 weeks we've heard talk from these two about a Confederate flag, which is a symbol of racism, you never should have heard it. It has nothing to do with this case. It has nothing to do with Chief Haig. It has nothing to do with the citizens of Greenfield. And it should never have been in this case at all. So what actually is in this case? Well, I'll go through it with you. You have lots of evidence. You have tons of documents. You have access to all the audio recordings. All you have to do is ask, and you'll be brought back and played whatever you want to hear. I played for you a portion of Mr. Buchanan's interview. You can hear that portion again if you like. You can hear the whole thing. I've played for you the portion of that terror-filled woman who called to alert the department that Todd Dodge was giving out her name and she might be killed. You can hear that. So let's walk through what happened here. So understand something. You do understand, you have seen, haven't you, that these two have tried to keep evidence from you and him. If you were to believe the evidence that they wanted you to consider is Mr. Buchanan testified that all his troubles began in 2015, that he had never had any internal affairs complaints against him ever, and that all of his upsetness, his disturbance, all began as a result of him not getting promoted in 2015. And you heard the evidence of how hard it was to get a hold of his actual therapy records from Dan McLean, who, by the way, was not called to testify. His therapist from 2005 until 2021, he was saying Dan McLean. And Dan McLean and Mr. Ryan and Mr. Buchanan did not want you to see those records. Because what does it actually show? And now you can look at them all. What it shows is that Mr. Buchanan, in 2005, a few years after he started, reported to his therapist he had trouble following through in work. What's the evidence that you have in here? Any evidence at all whatsoever of race is the term that the chief, in 2013, said that he did not think that Buchanan should be a sergeant because he was lazy. And they want you to believe that that's a trope. That's sort of shorthand. Well, laziness means that you don't do the work you're supposed to do. You choose not to. And you will see it's throughout his records. Who else had the same thought? Todd Dodge. Todd Dodge, his co-plaintiff, you heard unrebutted evidence, unrebutted testimony, that Todd Dodge never recommended him for sergeant. That Todd Dodge told the chief he shouldn't be a sergeant. And that in 2013, so let me walk you through and you can look at them. In 2005, Mr. Buchanan reported that he had difficulty with follow-through with duties at work and a history of depression and social anxiety. Depression long before any Chief Haig allegedly did anything to him whatsoever. It's unfortunate, but that's the real story. In 2006, he reported that he needs to follow through with work-related assignments because they're boring and tedious. He didn't feel like doing it. In 2007, he said that he had struggles with the administrators, not this one, other people in the department. Then we have, in 2009, he reports that he has ADD work-related issues, low productivity. He's not doing his job, he says. And they're linked. The reason he's not doing his job is because he had preoccupation with recreational interests, boating, which distracts Pat from attending to work issues. In 2009, he enjoys boating. That's great. And the boating distracts him from actually doing any work. From sitting at the tire warehouse and doing nothing. In 2010, March 17th, he has been successful in limiting his activity levels at work and confronting superiors, not Chief Haig, due to his objective of securing retirement income in 10 years. That was always the plan. I'll do as little as possible. I'll work midnights. I'll do as little as possible until I get my pension in 2021. That was his attitude towards his policing work. He was busy with boating. He had a video business during the day. And work was just a way to get money from the citizens of Greenfield for sitting at the tire warehouse. In 2013, before any of the things that happened here, there's a note that he discussed avoidant behaviors at work due to co-worker tensions that have led to legal action for alleged harassment racism. Avoidance at work. He was avoiding his co-workers. He was working midnights, which Sergeant and then Lieutenant Dodge wrote is a way that, that he holds that against people who want to get ahead, that they don't move up the midnight shift, they don't join the day shift, they're not seen. He called it hiding in the darkness, is what he referred to. In 2019, he has been expending minimum effort at work. Also in 2019, when you look at his PCP records, it says he retires at the end of 9/27/2021, his birthday. Remember the story he told you when he was on the stand about how he had to retire because he couldn't physically do the work and it was just too much and decided to retire? And he was thinking about it even though I took his deposition and he said he hadn't decided yet. He decided long before that the end of his employment at the police department was going to be 9/27/2021, which it was. He put in his papers the next day. In fact, it's his birthday, his 54th birthday. And in fact, chose not to do any real work, to basically take the money that the city of Greenfield was paying him and do nothing. one of my all-time favorites when we finally got these, despite the efforts of Mr. Buchanan's legal team for us not to ever see this. In January of 19, he was advised to do, quote, the bare minimum, which is what he did. If you go through those records, you will see what was going on. So, why did everyone perceive him as someone who wasn't doing his job? They would have to believe that this is because of his race. All you have to do is look at his therapy records, look at his activity records. Activity records. What Mr. Ryan presented to you was one of the silliest comparisons in the history of man. Career activity, cumulative totals. Said, look, he's number 6. Sure, he's number 6. Compared to officers who've been there for a year. He wants you to compare officers who were there for 3 years to Pat Buchanan who was there for 21 years. Those activity records are career records. So if I become a Greenfield officer in 2019, he says, look, he doesn't have very many arrests compared to Pat Buchanan, whose arrests go back to 1999. You have the actual activity records that we provided you. They're in there. They're in the books. And you'll see this last 2 or 3 years, he was averaging about 1 citation a year. It's absurd what he was doing. But he had a lawsuit pending. So, do you think that Chief Haig was foolish enough to terminate him for not working? But that's in fact what he was doing. He had a plan. On 9/27/2021, I'm retiring. And up until that time, I'm going to do nothing. I'm going to sit there. What did he say he did? He read the paper. He studied. He watched the world go by. That's what he did. And he wants you to believe that because Chief Haig thought that he wasn't working hard enough to earn the role of being a sergeant, it's because of his race. He wasn't judging him by his race, he was judging him by the color of his work, of what he was doing, as was everybody else in that department, including Todd Dodge. Everyone else. He was, in fact, not working. What the chief said was completely accurate. Now let's walk through the claims, because there's many, of Mr. Buchanan. Mr. Dodge has no claim, but we'll get to that. What are Mr. Buchanan's claims? Well, he's been silent on his attempts to become a sergeant prior to 2014. But you see in the records, he did try. He didn't make it. So we're clear on the evidence about these lists, and the short list and everything else. When there's one opening, the department was the civil service department until 2019. When there's one opening, they have to have 3 people that are approved by civil service to pass the test. If there is, then they have to hire one of them. They can hire anyone. They don't have to hire the top one. But if they don't hire the top one, they have to give a reason. If there's not a full number, then the city doesn't have to do anything. Doesn't have to hire anybody. There's no mandate to hire. So what you heard was, the evidence is uncontroverted. There was an old list, there was a list from a prior exam in the spring of 2014, on which there was only one name. And that person was a veteran. The person who decides who to hire, not to hire, is not Chief Haig. Chief Haig came into that department with a shortage in every position. He wanted to fill them. But it was Mayor Martin. And Mayor Martin said, even though it's a short list, I'm going to hire him because he's a veteran. And he hired him. It had nothing to do with Mr. Buchanan whatsoever. Then, there's another exam in the fall of 2013, regardless of what these people keep saying, that there was somehow a mysterious exam in 14, which never happened. It was in 13. And in April of 14, the new chief asks for a list to see if he can get the mayor to hire some people. And the list only has 2 names on it, Buchanan and Haskins. He gets the list in April. And the evidence is uncontroverted. The chief goes to the mayor and says, this is what we got. We need sergeants. This is what we have in the civil service list. And the mayor says, I'm not hiring. There's only 2. I want more candidates. The mayor, Martin, says that, who's not being sued, who's not being accused of racism. Well, maybe he will be now. So then, I just saw him writing. So then,
Objection, Your Honor.
Sustained. That portion, maybe he might be, is struck. Please proceed.
so then, the mayor says no. And the department sorely needs, they need a deputy chief, they need sergeants. So they go to an assessment center. Which they did with the deputy chief in the summer of 14. They also happened to do with the fire chief. And they do the assessment for the sergeants the next year. There is an assessment center run by Chief Pomeroy. Totally fair, totally blind, totally neutral as to race, color, creed, age. And Mr. Buchanan doesn't make the top 2. I mean, he would have you believe that the investigation of what he did to that young man had something to do with the assessment center or with anything. The fact is, the chief, even though he couldn't get the mayor to promote anybody off the short list, made Patrick Buchanan a provisional sergeant. He didn't have to, but he did. And then what happened? You had the incident with the young man. And they call it play it forward. It's not play it forward. He was not disciplined. He was not investigated because he gave the young man a warning and suggested to him that he should give his mother a present. That's a wonderful thing to do. What is a violation of anybody's civil rights is to tell them that if you need to give me receipts, and if you don't, I know where you live, and I'm going to take police action against you. Everyone here agrees that's illegal. But that's what he did. So what do we know is that a couple of sergeants are talking and they hear about this, they pass it up the chain, and Lieutenant Byrd says this needs to be looked into. And you heard the tape. You heard that Mr. Buchanan lied. When he was initially asked, did you tell this young man to bring you the receipts? He said no. And you heard what Lieutenant Byrd did, which is a really nice thing of him. I'm going to give you another shot at this answer, Patrolman Buchanan. I'm going to give you another shot at the answer before I take this answer down. You should really think hard and talk to Dodge about it. Do you really want to stick with the answer? And then Patrick Buchanan admitted that he did order this young man. It's not a request from the police officer to tell you, bring the receipts to me in 5 days. So the problem everyone had, Lieutenant Birch had, with what Pat Buchanan did is, A, he denied it, and you saw that the letter says that Patrick Buchanan admitted the stand that he had done that at least 5 times before. He had been doing it regularly. And so you heard that the mayor, Mayor Martin, wanted to fire him for doing this, and that the chief fought for him and told them that the mayor, don't fire him. The chief that's being sued for racism told him, don't fire him. How about just give him a 3-day suspension? And then Todd Dodge never once said to anyone, any of this is race related. The so-called whistleblower never told a soul that he was blowing the whistle on discrimination. Ever. And he admitted that to you. You remember what he said? I was too smart for that. I'm too smart to tell somebody that's discrimination. So we have a grievance, and you have the result. The arbitrator found. Okay, so the first thing they're complaining about, he didn't get the sergeant's job in 14 off the short list. Then they're complaining that he was demoted from being a provisional sergeant in January of 50. You see, the arbitrator found that the demotion was appropriate punishment for what he had done. The arbitrator agreed with the chief, with the mayor, that he should have been demoted in 2015. Then we move ahead. What's the next thing that happens? Well, the discriminating chief promotes Mr. Buchanan, the then patrolman Buchanan, to provisional sergeant. And he's running the midnight shift. And they let him run it until the entire shift complains that he's a bully, that he has no leadership skills, that he's constantly second-guessing them. You can read it. Now the chief is faced with that, and also some of them are complaining that Westerling, the other sergeant on the midnight shift, is not backing them up. That he's sitting in his office, not coming out. So he's driving around being a bully and bullying them everywhere, and Westerling's not doing much. And you heard the chief sought legal advice. What do I do now? We're being sued by Buchanan. And he got advice, you should hire somebody outside to do Buchanan, so we're not here as I suggest you. We likely would have been had they investigated, the department investigated, then Mr. Buchanan said that's retaliation. So he's investigated. You have the report. Every officer on that shift complained about Pat Buchanan and his style. And as to Westerling, every officer said, actually one officer said he never had problems with him. Another 3 officers said he used to not come out, that he's self-corrected, he's coming out now. And Pat Buchanan's reaction to every person on his shift, for what it's worth, including a person of color, that he's a bully and that his style isn't flying, he has no leadership skills, is to say to Chief Donovan, they're just going to have to get used to the way I am. That's how I am. But did the chief take him off the provisional sergeant as a result of that? He did not. He got a letter reprimand. Which I don't believe he grieved. Then we move forward and we have a situation where they're short of people on the road. And so the reason he was removed from being a provisional sergeant then was because it had nothing to do, there's no evidence that it had anything to do with Donovan's report or any of those things. He was removed because they needed more people on the road and he was the junior sergeant. And by this time, you will see, he has decided to do nothing and is doing nothing. And is planning now, we're into 2019, he's planning now on retiring on September 27th, 2021. So he goes to the tire warehouse, he does absolutely nothing, but he puts his name in for sergeant again. And you will have there are notes in evidence of what every one of the lieutenants and sergeants said about all the candidates and his candidacy. And you have in the evidence of what Lieutenant Dodge said about his co-plaintiffs here candidacy. The man who they are here trying to persuade you that the only reason he wasn't made a sergeant at that time was racist. Because they're complaining about that one too. Well, one of the reasons he wasn't made a sergeant at that time, one of the reasons was what Todd Dodge said, which was, it's been tried before, it doesn't work. That's what Dodge said, don't make him a sergeant. That's what every one of the lieutenants said. One lieutenant or sergeant, I forget who, says he doesn't do anything. A fact. A fact that Pat Buchanan told his therapist repeatedly, his doctor, I'm not doing it. I'm going to do a minimum amount of work. And he doesn't get promoted. So you have 14 not promoted because the mayor wouldn't do the short list, and 15 there's an assessment center, which is completely fair, in which he finishes third. And then you have another promotional process. You have 4 promotional processes. And they complain about his demotion from being provisional in January of 15, and you see the arbitrator agreed with it. The arbitrators, in fact, agreed with each of them, with each of the recommendations of the town that Dodge and Buchanan at various different times needed to be disciplined for what they did. What they're arguing was the level of discipline. Let me talk briefly about Todd Dodge. Todd Dodge wants you to pay him. You're going to hear his lawyer ask you for hundreds of thousands of dollars because he was a whistleblower. And he says, as a result of standing up against racism, he was investigated because he called and told the convicted felon he was going to give him the name of the woman who complained about him. And you heard her call to the department, which triggered this whole thing. He said that was done because he somehow blew the whistle. What did he actually do? He claims. He says that in 2014, the chief told him that on this list we need to find some way around, or some way to find a different way to get a list. He says, I said nothing to the chief. He doesn't claim for a moment that he said anything to the chief, that this is wrong. What in fact happened is he, Lieutenant Williams, then Deputy Williams, and the chief worked on getting an assessment center. Actually, before he became deputy, first they worked on an assessment center for the deputy, then they worked for an assessment center for the sergeant. Nobody protested that the assessment was wrong. Todd Dodge has told you he thought it was correct. Todd Dodge never said to anyone, never wrote to anybody, never hinted to anyone that he thought this was wrong because of racism. Never. On the grievance, which you will hear claim is somehow of a whistleblower, the grievance is a routine contractual provision that if a police officer has something negative, some discipline, which is grievable pursuant to contract, as is a suspension, that the union will then grieve and say he's been punished too much, or shouldn't be punished. There's nothing in writing or verbally that Todd Dodge ever said this is all happening because of race. I'm protesting. He didn't tell a word. He never blew any whistles. So what's he complaining about? He's complaining about the investigation of his calling the felon and telling him, I will find out who complained about you. And I will tell you. And that poor woman heard that phone call. And that resulted in her panic call to the police department. That's why the investigation happened. It had nothing to do with anything else. And please read Deputy Williams' report and his conclusions about how he recognizes that Todd Dodge is a 18-year veteran, that he had a momentary lapse. But he's concerned because Dodge refuses to agree, refuses to recognize that what he did was wrong. And Dodge is so callous that he says that woman has chosen her lifestyle, so tough luck. She's chosen to hang around people that might kill her, so tough luck. Read that report. That was his attitude. Still is. He's never done anything wrong, as far as he's concerned. But one thing he never did, as he said, he was too smart to blow a whistle. Todd Dodge doesn't deserve a penny. Oh, and on the, take a look at his tax returns. It's really interesting. What does he claim money for? They claim because he lost overtime. They claim that his lost wages are, he lost overtime. Remember, he was suspended, he got all the money back. The arbitrator says he shouldn't have been suspended, so he was made whole. So what did he lose? Well, Todd Dodge says he lost all this overtime. Well, he was on administrative leave for 2 months. So let's say there's 2 months of overtime that he lost. That's it. When he came back, he had started a business. Take a look at those tax returns. It'll show you what was going on. He started a business, a landscaping business. He had all these paper losses because he was investing in equipment. Had nothing to do with anything the town of Greenfield did to him. He chose to open a business. That's why his income dropped. If you actually look at his tax returns, you will see there's no evidence in there from which you can come up with any kind of numbers that Mr. McDonough is about to tell you, because they don't exist. He chose to, instead of working overtime, to go business with his son, which is great. We all support that. And he also said, okay, so he went into business with his son. He doesn't get compensated for choosing to do that business and not doing overtime, that somehow the department forced him not to take overtime. One moment, please. Good point. One other thing. You heard Mr. Ryan say that, suggest to you that some of the other people that got promoted in 2020, that their numbers weren't great either. Take a look at the evidence. You will see they're detectives. They're not patrolmen out there patrolling the streets. Well, who are supposed to patrol the streets. They're detectives. There was never any issue that any of those people were not doing the job they were supposed to be doing. But the fact is, and by the way, you also see in his medical records that he reports that supervisors have talked to him about his absence of productivity and his abuse of sick time. People were talking to him about the fact that he wasn't doing much. Mr. Buchanan made the decision to stop patrolling the streets of Greenfield. Mr. Buchanan has known the chief. I suggest to you that both of them know that Chief Haig did nothing racial here. That anything that happened to Mr. Buchanan was related to his race. If Pat Buchanan wanted to be a leader in the Greenfield Police Department, he would have gotten out that midnight shift as soon as he could. He would have worked as hard as he could. He would have volunteered for assignments if he could. But that's not what he wanted to do, and it's his choice. Is it fair to the citizens of Greenfield? No. To have a patrolman who decides he's going to sit at the tire warehouse and do nothing and not enforce any laws? No, it's not fair to them. But that was his choice. There's nothing that you've heard that the chief said about him that wasn't true. There's no evidence in here that anything that he did was race-based whatsoever, especially now that we finally, it's been recognized that Confederate flag, which is so inflammatory, has never had any part in this case, never should have been in this case. It has nothing to do with that man. And Chief Haig and I and the mayor were confident that you'll go in the jury room and you will reach the correct verdict, whatever it is. We have faith in you. Thank you.
Thank you, Attorney Kessin. All right, very well. Attorney Ryan.
Thank you, Your Honor.
All right, Attorney Ryan, since you're sharing your time, I'm not going to give you any time markers.
You will. Good morning, ladies and gentlemen. I join with Attorney Kessin, Attorney McDonough, the judge, the clerk, thanking you for your devotion to this case. thanking you for coming back day after day.
Council can speak a little louder, please. Thank
Yes,
you.
Your Honor. Thanking you for coming back day after day and being involved and being ready to hear the evidence. Your commitment and devotion to this case is, it's the only way we can get this done, so thank you very much. This case has to do with a failure to promote. Attorney Keston talked about a prior promotion that Pat was denied. That's not before you. What's before you today, ladies and gentlemen, is the failures to promote from 2014 forward. And there's about 6 of them. There's a failure to promote off the short list in 2014. There's a failure to promote when they use the, he's lazy, see what you can do, get around. They promote him and then demote him within a week. The assessment center, he comes in third by a point, 1 point. It's in the records, 1 point. He's promoted again to provisional sergeant. They said, would you like to do it? Because he's still number 1 on that assessment center list. So they promote him. And as soon as Jimmy Rhodes, as soon as that list concludes, because Jimmy Rhodes went out 2 days to the day of his promotion. He was promoted October 1, and the fatal accident was October 1, 2 years later. And Pat's promoted 2 months later, or 2 weeks later. But as soon as that list is expired, because it would have expired 3 years out, August, September 2018, whammo. Whammo. Let's go after Pat. Let's get the Midnight Posse together. Let's go after Pat. And then in 2021, or 2020, they pulled Pat off in 2019. And they give it to Sergeant Clark a year later. He's made a provisional. Not Pat. No, Detective Clark.
I'm sorry, I can't hear you.
Okay. Detective Clark has made a provisional. Thank you. And then in 2021, there's 2 things that happen. The chief scores Clark with all of the history that we're going to get into at an 80. And the chief has 40% of the grade. So Clark's an 80. Pat Buchanan's a 54. 26 points below. You can't reconcile that. You can't reconcile that in the real world. And even with that, because there's the unforeseen departure of Deputy Chief Williams, there's a 4th promotion available. Pat Buchanan is next. The mayor didn't even know that he was rated. She didn't see the document until she was here. Rather than take Pat as the 5th candidate, as the next ranking person, they take a lower scoring white man. Pat was a member of the patrol division for his whole career. The patrol division are the men and women who go around and answer call to call. Pat's been a field training officer and an officer in charge. So that's when there's no sergeant on the ship, the ranking patrolman becomes officer in charge. He's been that since 2008. When we had Mayor Martin here the other day, he boasted about the great work they did in diversity recruiting. Ramos and Soto were long gone before Patrick. And Patrick was the last officer of color on that department. So when he retired, those boasts of a diverse police department are out the window. Patrick testified to some of the things he's heard, as to things he's been told about Chief Gilbey, former Chief Gilbey, using the N-word. Lieutenant Acting Chief Gary Magnan, using the N-word with respect to him. And then we have Sergeant McCarthy. Sergeant McCarthy filed 5, and they're in this book, IAs against Pat. The IAs include taking gum from a guy on a work detail. Really? Why are you watching this guy? What's the relevance that you're watching this guy taking gum and you feel it should be reported? Another one is Pat was several minutes late for an outside work detail and it gets reported. McCarthy was a complainant, identified as a complainant, and it's in tab 1, exhibit 3 on the January 2015 IA. McCarthy was an evaluator in the 2020-2021 process. There were no lieutenants. There's evaluation from 4 sergeants, and McCarthy's one of them. Those 4 sergeants, the chief had this process where he took notes of what they said. It's only worth 5% of the, or 10% of the grade. So for each individual, it's 2.5% of the grade. But McCarthy did evaluate Pat and gave him a very low and negative review. Not surprising. You heard about Pat with Brickett Alice. Now, in those reports, there's going to be about 5 IAs brought by Councilor Brickett Alice. He's a city councilor. He's an elected official. Pat's the only officer of color. And we referenced one the other day in which Brickett Alice went on Facebook, posted on Facebook that Pat was harassing him because Pat was following Sergeant Dodge's direction to make sure the bars are closing when they're supposed to. And so Councilor Alice puts on the thing that Pat Buchanan's a bad guy, he's targeting me. And what that IA shows, the next day he talked to Dodge, and Todd Dodge says, oh no, he was following my instructions. Never an apology to Pat Buchanan, but the IA went away. There's another IA where Brickett Alice complains about the fact that Pat, police officers are human like the rest of us, they get dinner breaks. So Pat's at a dinner break getting takeout food. And while Pat's on dinner break, the radio goes off. And so he has to get his order and then go to the thing. But again, there's a Facebook post by Councilor Alice, a charge by Councilor Alice that Pat's not doing his work. Pat's the first one to get to the scene. The IA is exonerated. But this is the kind of thing you have to put up with. My brother talked about all the IAs, but go back to the arbitrator's report on Pat. He said Pat had an exemplary record and no prior discipline in his 15-year career. That's what the record is, ladies and gentlemen. His first discipline was the January 2015 discipline. We heard from the chief and we heard from the mayor, Mayor Martin, about the hit squad and the midnight posse. These were inventions, pure inventions. That somehow this guy, as a young cop, is going around terrorizing elected officials and their friends. Mayor Martin was an elected official from 2004, and he was the mayor from 2009 or 2010 for 10 and a half years. They wanted you to believe that there was the hit squad or the midnight posse of these people going out and terrorizing. Not one document to substantiate either the hit squad or the midnight posse. Nada. And so it goes to, was Pat abusing his authority as a police officer? Absolutely not, because if there was any truth to it, they have all the records. They would have produced records. Greenfield claims, my brother claims, in great detail, that Pat was lazy. If you look at the exhibits, Exhibit 1, tab 33. So that's the exhibit of there's 2 lists in here, ladies and gentlemen. There's the 10 candidates who were up for promotion in 2020, 2021, and then there's everybody else. 138. So on the short list, the 10 candidates who are for promotion in 2020, 2021, Pat's first, second, and third in essentially all the categories. Detective Clark precedes him by many years. With respect to the longer list, which is the second, the last page is about 7 or 8 pages in that, Pat is number 5 in active duty stats. Number 5. So, the idea that you're lazy, what the hell are all these other people doing? He's out there going from call to call, answering the bell, and doing smart and effective policing. Intelligent, thoughtful policing. Rather than ticket the kid, he says, we'll do something else. He could have ticketed the young man. He could have given him 2 or 3 tickets as a minor operator. Probably caused him to lose his license. Certainly would have had a big fine and insurance surcharges to pay. And he thought, wouldn't it be wise just to give the kid a warning, pay it forward? The other records that my brother talked about are at Exhibit 4, tab 45. And those records relate to the last 10 years. And if you compare Pat Buchanan's performance with the other men and women who were selected for promotion in the 2020-2021 timeframe, his records are better. His production is higher. And Sergeant Clark had gone back to the back to the uniform division sometime prior. But Pat's arrests during those 4 years or 5 years are substantially higher. It's about 50% higher than Green, Gilbert, or Clark. The discriminatory acts, ladies and gentlemen, we submit are the 2014 civil service test and not using it. Westerling was taken off that, and it's not that he wanted the veteran's preference. Westerling was promoted with less than 9 hours to go. He promoted at 3:05 in the afternoon on 2/28. The list was expiring at midnight. He'd been on that list for 2 to 3 years. Veterans preference, I've got to be prejudiced in favor of veterans. That's an excuse. It's not the real reason. They had no objection to Westerling. When Pat shows up on the list, it's clear what happened. Both Todd Dodge, number 1 man in the department for productivity, and even the chief agrees he's a very good cop. Todd Dodge says the chief told him, lazy, doesn't fit the bill, see what you can do to get around civil service. Now when Deputy Williams was here the other day, he agreed. Chief Haig never said anything good or complimentary about Buchanan. And he also agreed that Chief Haig said of Buchanan, he's lazy and he doesn't fit the bill. There's really no dispute, ladies and gentlemen, as you have 2 senior members of the command staff who put those words in the chief's mouth. I submit to you, ladies and gentlemen, that one of the reasons the 2015 investigation went forward with the full guns that it had, there were 13 witnesses interviewed, is because they knew the chief didn't want to promote this guy. They knew he was up for promotion. They knew he was at the top of the list. And so if the chief has told 2 people in a very small command staff he's lazy and doesn't fit the bill, it's logical. You can infer that Lieutenant Burge heard similar statements from the chief. And so Burge digs in, goes out and investigates 13 people. They even tracked down the car to make sure that it hadn't been spent. And all this was done to make sure Buchanan doesn't get traction towards promotion. The arbitrator found the suspension was unwarranted. There was never a quid pro quo. No evidence that Buchanan made any effort to pursue and was generally surprised when the young man returned the receipts. The assessments, the suspension and demotion did impact Buchanan. It did impact his role in the assessment center because in addition to the assessment center, there's a review within the department, and it's detailed in Exhibit 1, Tab 15, and that's work and experience and service file reviews. Pat came in 5th in those. Pat came in 5th out of a 7-person field because he had the suspension, he had the demotion.
Sidebar.
Yes, is the objection. There's no such evidence. There's no such evidence that this is, he's talking about the public safety.
So that's not
Yes. He's talking about the public safety, it's going to be in the record that the evidence is that they never saw the suspension.
There's no evidence that they didn't see it, Your Honor.
Okay.
There's no evidence to the contrary, what my brother said.
Well, there's no evidence, and you can't argue it. Okay, so I'm going to strike that portion. Okay. Ladies and gentlemen, the last statement that Attorney Ryan made is struck from the record. Please proceed.
The department wasn't happy with a list that gave him Pat Buchanan at the top. They wouldn't promote from that list, but they were very happy, and they did promote from a list that had 2 white officers at the top and Pat Buchanan in 3rd place. Other evidence of discrimination, ladies and gentlemen, is the treatment of similarly situated people. Officer Clark, now Sergeant Clark, the IA, which is Exhibit 2, shows that he had a long-standing alcohol issue. Shows that the chief said there were rumors of his alcohol involvement before he came back to the department. Shows that a September 2016 report of intoxication at the fair, and that was on duty, or special detail, a light night car crash. Clark admitted in that IA that it came in, that in September 2016, that he'd come in either intoxicated or after drinking. And so in September 2016, the chief told him, we think you've got a problem, and we're going to require you to take a breathalyzer when we think you have a problem. On December 2016, he clearly is out of it. He drives a cruiser from the station down to the courthouse, and the chief is going to have him take the breathalyzer, but for some reason never does. So there's no record. There's no record of a positive reading. There's no arrest. There's no Miranda warnings. There's no proceeding that is normal with the criminal rules. Rather, the chief takes 2 sets of keys and drives them home. Pat gets 13 witnesses. He gets an audio tape. He's got to come in for an audio tape statement about a gift card. This other guy who's repeatedly in violation of the rules of the department, because you can't be drunk on duty, you can't come in smelling of alcohol, and in violation of the criminal laws of the Commonwealth. Nothing happens. The rules state that when you think there's a criminal investigation or a criminal issue, you refer it off to the DA. They did with Todd Dodge, sure as heck. But they didn't do it with Todd Clark. And I submit to you, his violation was a heck of a lot more obvious than anything Todd Clark ever did. But it shows the differential. And it shows the differential in treatment is the essence of the discrimination. Further discrimination is the treatment of the case involving the nurse, Miss LaFlamme. Now, she's a person who they do arrest for being under the influence. That's Exhibit 3. So we're not going to arrest our own people, and the chief, in referring to Todd Clark, and that's Miss LaFlamme. That's Miss LaFlamme at the booking. Miss LaFlamme was taken out of her home Miss LaFlamme had knocked over a mailbox, and she was taken out of her home. The report indicates that when they were arresting her, somebody put something into the small of her back, and she has scoliosis and caused severe pain. And it was one of the two arresting officers, either Soto or McDowell. And they brought her in, and they charged her, and they arrested her. And what happened with Miss LaFlamme is Soto, the guy who was bullied by Buchanan, Soto says to her, wouldn't it be funny if DCF found out about it? And there is a call, there is a referral to DCF. And in her statement, she says that they did this to me. Ms. LaFlamme called Soto to complain about it. She clearly lost her composure on the second half of that conversation. But it didn't warrant. It didn't warrant them, the chief, creating a punishment. Because, again, that's what Buchanan and Clark get. They get punished for creating punishments they didn't have the authority to give. But the chief calls the president of the hospital and reports that young lady. And she loses her job. He had deputy, he had lieutenants. He could have given him a call and said, will you go up and talk to this lady for 10, 15 minutes? Just smooth it over. We can go forward with the OUI. Or if they felt so scared, they could have charged her with intimidating a witness, which had been Soto. But they didn't. They go after her for that. I submit, ladies and gentlemen, that the other issues of discriminatory or adverse differential treatment have to do with the McCarthy IA, where McCarthy clearly violates the civil rights of that young man who he said, give me your phone. And it had to do over a failed romantic relationship between adults. He had no business doing that. The other area where they differential treatment, it has to do with Sergeant Road. Sergeant Road, the fatal accident was 2 years to the date of the promotion. Sergeant Road stayed out for 16 months on Section 111F. You only get 111F if you are injured without fault of his own. The statute says his own, so it's an old statute. But a police officer is only entitled to get paid if they're injured without fault. The town paid 16 months of money to Road that arguably didn't even have the legal ability to do. But we take care of our own, and he was one of our own. Pat Buchanan clearly is it. Pat, after the Road demotion, or the Road IO injured on duty, he's happy to take on that provisional. He's happy to do the work. And again, they come after him with written statements, totally differential as to how they treat Westerly.
$18 minutes left for plaintiff's closing.
Thank you, Your Honor. Let me turn to damages. Well, let me turn to the 2021. 2021, as we indicated, Pat applied for. He was eligible. He was on the list. Even after the chief knocked him down, he was still the next man up. It would have cost them nothing. It would have cost them nothing. They had a position to give. He's the next one up. And they couldn't bring themselves to do it. They couldn't bring themselves to do it. So, ladies and gentlemen, we're looking for you to return a verdict in favor of Mr. Buchanan. We're looking for you to say yes on the special questions that he has been the victim of discrimination. We're asking that you award him the back pay, which is in the chalk, Exhibit 1. It's approximately $88,500. That's the differential between what he would have made but didn't make. We're asking that you find emotional distress damages. We're asking that you find emotional distress damages that are commensurate with a period of over 7 years. Emotional distress damages that include panic attacks and changes in his personality. Finally, ladies and gentlemen, we're asking that you, and there's a question to you, asking that you find punitive damages. Punitive damages are against the city. Punitive damages may be assessed based upon a finding that the town, the city, has acted in violation of the law, that it has engaged in racial discrimination. And it's the town. The town's the employer, and it's the town that is responsible. And when you assess punitive damages, ladies and gentlemen, you have in there the budget. You have in there the budget for the whole town, which is about, I think it's at page 61 of that exhibit. It's about $60 million. The police department is $3.5 million, plus or minus. But when you assess punitive damages, we ask that you consider those numbers as you reach that verdict, and we ask that you return the verdict for Patrick Buchanan. Thank you.
All right. Thank you, Attorney Ryan. Attorney McDonough, you have just about 20 minutes.
Thank you, Your Honor. Speaking up for what is right and following the law. That's what our case is about. And on behalf of my client, Todd Dodge, I want to thank each and every one of you for your time and your attention, your service throughout this case, which again we maintain is about speaking up for what is right and following the law. Judge Mason will instruct you that there's a law in Massachusetts called the whistleblower law, and it forbids a governmental employer, like the defendant in this case, from retaliating against an employee like Mr. Dodge for engaging in any type of protected activity. The whistleblower part of this case is straightforward. It has three parts. Number one, that the employee engaged in protected activities. Number two, that the employer, the defendant, retaliated against the employee for those protected activities. And number three, the retaliation caused some harm, economic damages, lost wages, or emotional distress to the employee. Element one is simple, protected activity. And you heard evidence that Mr. Dodge engaged in protected activities. You might ask, well, what are protected activities? There's three types. And the judge, again, will instruct you on this later in more detail. The first type is disclosing an employer's illegal activities or threatening to disclose it so that it comes out to some sort of public body. The second is providing information at any such hearing, investigating illegal activity. And then the third type of protected activity under the whistleblower statute is merely just refusing to cooperate with an employer who wants to commit some illegal act. So not going along with some illegal act. Employer can't then come after you. Makes sense. And that's what our law provides. And in this case, Mr. Dodge's whistleblower activities began in October of 2014 when Chief Haig came to him with that promotional exam list with Patrick Buchanan, number one, and said, this guy's too lazy. This guy doesn't fit the bill. What does that mean? Doesn't fit the bill. He's number one in every metric, number one on the list. Only guy with a master's, most of the time in grade. As Attorney Ryan said, when compared to the others up for promotion, right at the top of the productivity. But he doesn't fit the bill. We submit the only, all the lawful metrics, he did fit the bill for promotion in 2014. And my client testified to you on the stand, he immediately understood what doesn't fit the bill means. And as if it didn't need more explanation, Chief Haig then went on and said, we need to find a loophole. We need to find a workaround to get around civil service. That is an invitation to commit an illegal act. That is violating the civil service laws, the anti-discrimination laws, and my client testified right on the stand. He absolutely never cooperated with that. There was nothing he could do under the law to cooperate with that, and he did not do so because it was wrong. That's protected activity. Once you do not join in your employer in an illicit, illegal act, that's protected activity. You may not be retaliated against. But it went further. In January, after Pat Buchanan gives a kid a break, a kid who's later an officer in that station, what a great outcome. They turn their apparatus through McCarthy. It flips from a thank you to discipline. And all of a sudden, it's being forwarded up. 13 witnesses. Let's go investigate this card. He didn't even use the card, but they went all the way to the Stop and Shop and found out it hadn't been used. They put all their resources into getting Pat Buchanan. And my client's asked to give a statement of what he observed, and he submits a statement in support of Buchanan. More protected activity. I saw him receive the receipts. He was shocked. He said, oh my gosh, the kid actually did it. And so Dodge is clarifying, no, you got it all wrong. Pat wasn't ordering this guy to get receipts. It was a comment at most. He was shocked to get the receipts. He's putting in another written statement for Pat Buchanan. They ignore it. They go on with the discipline. And when Pat Buchanan receives his discipline, he's looking for some help to oppose it because it's wrong. It's over the top. It's excessive. And you heard my client explain to you the process. He didn't have to take on that fight. He could have just said, you know what, I'm doing really well. I'm a sergeant. I'm looking at lieutenant again in the future, and I don't want to get involved in this. He could have said, go to the lower officers union. He could have said, have someone else in our union cover it. He said the union doesn't always cover cases. He gave you an example of an officer named Rice where they didn't take a gentleman's grievance. But my client, like I said, speaks up for what's right and follows the law. And he knew the chief was out to find a loophole or workaround. He knew the chief was willing to violate the law. And he saw what was happening to Pat Buchanan over a pay-it-forward warning to a junior operator. And he said, I'm in on this. I'm going to object in writing. More protected activity. He wrote an objection to Chief Haig to this discipline, which was completely beyond what the department had done with respect to other officers who had committed more grave offenses. He also wrote, and that's Exhibit 1, Tab 11. He also wrote to the mayor and said, we're going to take this to civil service. We're going to object. We disagree with this discipline. And those writings are more protected activities by my client. So now he's not only not going along with the illegal activities, he's not only submitting a statement into the evidence, into the investigation, that you guys have it all wrong, he was surprised to receive the receipts. He's now leading from the front as the union representative for this officer. And our laws, the whistleblower law, is designed to protect that activity so that he can't be punished for it. He continues the fight. They lose in front of the mayor. No surprise, as you heard, all the evidence filtered to the mayor comes through Chief Haig. When I asked the mayor about who should be fired, I said, did you hear about McCarthy, the guy who threatened to kill a Greenfield citizen? No, I never heard about that one. What about Clark, the guy who was driving drunk on duty on a cruiser to the courthouse? And Chief Haig himself determined he was under the influence at grand jury. No, I didn't hear about that. Remember when I asked Mayor Martin, did you hear about Chief Haig literally removing evidence of a bottle of vodka from Detective Clark's cruiser and no discipline resulting? No, didn't hear about that. Everything's filtered through Chief Haig. And in this case, after they lose at the mayor's hearing, they keep fighting. My client keeps fighting. And you'll read in the exhibits, in Exhibit 1, tab 13, the arbitration decision, when it finally goes before a neutral third-party reviewer, an arbitrator, somebody outside of the city, that arbitrator finds in favor of Pat Buchanan, vacates the suspension, and notes that the union, my client, the union representative, argued that the city violated its own progressive discipline policies, which are also in evidence at Exhibit 1, tab 25. Progressive discipline. You don't just go for a suspension on the first instance. You warn someone. You counsel them. Maybe you have them teach a course to the younger officers on how to do it right. You don't just go right to unpaid suspension. But they did that with Buchanan because they didn't want to promote him. And the arbitrator found that was a violation of the city's own policies and laws requiring progressive discipline that Mr. Dodge fought the good fight on. They win, October 2015. The suspension is vacated. Within 60 days, we move to the next element. After protected activity, we move on to the city's retaliation against Mr. Dodge. Within 60 days, they turn the apparatus against Dodge. Well, we lost against Buchanan. Let's get the guy who stood up for him. That's against the law. And what you see here is later what we find in that arbitration is they use, quote, an unintentional slip of the tongue, end quote, that warranted no more than a mere written warning. They turn it into another large investigation and disciplinary action against Dodge. And as we heard, Dodge receives information from another officer that a woman called the station about her husband, wanted him taken to court. Dodge calls the man's employer, says, can you send him to court? He's got business to take care of, and his wife's upset that we're not doing anything about it. And he admitted. Was Attorney Keston correct in saying that he's never taken responsibility? Twice on the stand. He said, that was wrong. I shouldn't have given that information. He also testified he had no idea it was an anonymous tip. He had also had no idea that it wasn't actually the wife calling. He had been duped just like the recipient of the call and the entire department. But he did admit, that was wrong. I shouldn't have given that information. But how does the department respond to that? Did they follow their own laws? Did they listen to the first arbitrator and engage in progressive discipline? Remember what the testimony is about Mr. Dodge. No prior discipline of any kind ever substantiated against him in his 18 years. Top of the list in productivity. Everybody's testified he's a great cop. What do they do to him? They put him on the sideline on admin leave for over 60 days. They take the case, investigate it way further than they investigated Clark, further than they investigated McCarthy for threatening to kill someone, further than they investigated McCarthy with respect to the drugs and the money not adding up in the evidence locker. And they investigate him again. Let's get him. Let's get this guy. We got something on him. And what they did in that case was they referred it, unlike Clark, they referred this one to the district attorney's office. Again, no evidence that anyone was ever actually harmed. No evidence that my client ever knew that there was another person posing as the caller. No evidence that he ever did give the information to anyone. And what they do is they refer to the DA's office, and the DA responds, "We've seen no viable criminal activity here." Did they take him off admin leave then? Give him a warning or some sort of remedial punishment or low-level punishment where you start in progressive discipline? No, they kept him on admin leave. And then they gave him an unpaid suspension. The maximum unpaid suspension allowable under the law for a first-time offense. Of course he opposes it. He takes it outside the city to an independent external arbitrator. And this is a separate arbitrator, by the way, for the second time, an independent arbitrator reviewing how the city imposes its discipline. The last page of Exhibit 1, tab 24, if you look at that last page, that second arbitration, he says, this was inappropriate. He has a perfect record. There's only one possible infraction here, the arbitrator finds, and the arbitrator describes it as an unintentional slip of the tongue. And that on such a first offense, for such a minor offense, there's absolutely no justification to give this guy 60 days admin leave, refer to the DA's office, give him a maximum suspension. And what are the words the arbitrator uses? Again, the independent arbitrator. They want you to look at Williams and his report. I say look at my client and his word. Well, why don't we look at the independent third party that reviewed everything on this matter? And what did that person find? What they did was excessive, and I'm quoting, excessive and, quote, unjustified. He didn't just find it inappropriate or wrong. Excessive and unjustified. Why was the punishment excessive and unjustified? Because they wanted to get Mr. Dodge for his year-long standing up and speaking out for Officer Buchanan. Why was that retaliatory? Because it was excessive and unjustified. Because it was far more than what they did against other officers who were not whistleblowers, who committed far more grave misconduct. And because, as the judge will instruct you in this case, you may find that the mere proximity of a protected activity followed closely on the heels of an adverse action against an otherwise well-performing employee. You may infer automatically that that's retaliation. And I submit to you that it is. When you have a good employee, no one disputes he's a top performer, he engages in a year of protected activity, and within 60 days of winning at the arbitration, bang, they take a minor slip of the tongue issue where they could have said, Judge, you can't provide that info. Here's a written counseling. Maybe teach a class to the guys and the men and women who are newer on how to handle this. No, they went and maxed him out after sitting him on the sideline for 60 days. That's retaliation. And in tab 25 of Exhibit 1, you can see their policies. The city requires, under their laws, progressive discipline. They're violating their own laws to get Buchanan a first-time offender, to get Mr. Dodge a first-time offender. Because they're retaliating against them, they have an agenda. Those are the first two elements. Protected activity, retaliation of the employer. The third and final is that it caused harm. And here in this case, the judge will instruct you that there's two forms of harm with respect to Mr. Dodge. With Mr. Buchanan, of course, it's lost wages, emotional distress, and punitive damages. For Mr. Dodge, it's the statute controls it, and it permits lost wages and emotional distress. No punitive damages for Mr. Dodge under the whistleblower statute. And with respect to the lost wages, the evidence is clear. And Mr. Keston makes an argument up here, but he didn't ask Mr. Dodge one question about his lost wages. But when I asked Mr. Dodge, I said, what kind of worker were you? He said, well, I made $80,000 through 2016. But in addition to that, he said, I also took every detail, every overtime I possibly could, I took, because I loved the job. It was his identity. It was his life. And so he made an extra $30,000 to $40,000 a year on those extra shifts. That was through the year 2016. Then in 2017, all this happens. He's sidelined for 60 days. He's given the maximum suspension, and it changed him. It changed him. You heard him talk about how he'd explain to his daughter how he's really not, I guess, the hero that she thought because he's been disciplined now. How he couldn't even tell her at first. He had to lie to her. But then he came clean to her and said, I've been punished, I've been disciplined. And how heartbreaking that was for him. You heard him talk about how driving to work then, something he loved. He loved being a police officer. Driving to work would make him nauseous. Or a call from a supervisor, hey, I need to talk to you, would make him nauseous. Is this going to be some other ticky-tack, quote-unquote violation that's going to be the end of my career, my public life? Am I going to be fighting for my job again in the public in the public scene? And so he stopped. He just couldn't bring himself to do that. They took a man who works $30,000 to $40,000 extra every year and brought him to say, I guess I'll just try to start a landscaping company instead. And he told you it's never been profitable, and those tax returns are on the record. And what he told you is corroborated, because you'll see that in addition to the $80,000, I think the final year before the retaliation, he made $38,000 more. And so that's why we do ask that for lost wages, you take the midpoint of $30,000 to $40,000, and you get him, and you award him $35,000 a year for each year, 2017, 2018, 2019, 2020, 21, and then a third. We're 4 months into 2022. 5 1/3 years times $35,000 is $186,000 in lost wages that Mr. Dodge has lost out on from the time of this retaliatory action. The law also recognizes emotional distress damages, and Attorney Ryan pointed out to you that those are real damages that in each case the law provides to these plaintiffs if they've proven that to you, and each of them has shown you medical records, my client included, his therapist that he went to see about this, how he was struggling with this, the added medications, doubling his anxiety pills, his depression pills for this case. Because again, there's that fear. You took my identity. You took my client's identity, his identity as a police officer with an unblemished record, and you replaced it with a sword dangling over his head. When's going to be the day that it all just gets wiped out and now my record is I'm a failure because I did one small thing wrong and you're coming after me for my job, threatening to fire me or giving me maximum suspension. He's lived with that for 5 1/3 years. And we submit that it's harder to calculate emotional distress damages. It's not like the wages. We can easily point out to you he averaged $35,000 a year more and there's been a drop-off every year since this happened. That's easy to calculate. 35 times 5 1/3 is 186. Emotional distress is more difficult, and that's why we submit to you a range, and we put it to your judgment and your collective wisdom. We submit that the proper range for emotional distress damages for this, my client's 5 1/3 years, Mr. Buchanan approximately 7 years, is around $250,000.
That's to object.
Sidebar, please.
Okay.
He can't argue for Buchanan. He's about to give him a number for
He
Buchanan.
wasn't arguing for Buchanan.
He just said my clients and Buchanan's.
I'm agreeing with the ranges. I'm going to say the
Oh,
same
I
range.
certainly say my client. You can't say my client and Buchanan. That's correct.
Okay.
And also Buchanan he never gave him the range.
He never did. No,
Right.
that's correct. I just
You
heard you say
forgot.
my client. Okay, that's struck as to Buchanan.
Thank you, Your Honor.
All right, Attorney Buchanan's very last sentence will be reformulated. It is struck and may reformulate it.
Let me rephrase. We submit that the proper range based on your collective wisdom and judgment, common sense, and the evidence you've heard, is approximately $250,000 to $500,000 as a minimum range to use for such a lengthy period of emotional distress. And that's the appropriate amount that we think that you should look at.
Sidebar, please. You have to make it clear that you're relating to Todd Dodge in light of what you earlier stated, because it still sounds like you're referring to both plaintiffs, okay?
Will do, Your Honor.
Ladies and gentlemen, Attorney McDonough is presenting his closing argument only on behalf of Mr. Dodge in terms of his claim for damages. Please reformulate your statement.
That's right. I'm speaking to Mr. Dodge's damages, and we submit that $250,000 to $500,000 is an appropriate range, and you can go beyond that if you decide to do so. But that's at your discretion, and we believe that you will make the right decision on that. Again, we're talking about years of that nausea, that sick to the stomach feeling of taking the greatest thing in one's life and turning it into the greatest worry in one's life. And that is real, and that is something that Mr. Dodge has testified to.
You have 1 minute.
Thank you, Your Honor. In conclusion, the evidence here has shown two disciplinary systems. One where just so happens all the white officers, whenever there's a discretionary decision to make, they get the benefit of either progressive discipline or no discipline. And then the one black officer in the department and the one person who speaks up for him and says, this is wrong what you're doing to him, they get maxed out or they get suspensions, unpaid suspensions, 13-person investigations. And then that's wrong. And again, this case is about speaking up for what's right and following the law. The evidence shows that Mr. Dodge saw obvious and clear discrimination against Mr. Buchanan, a man who was first on the promotion list and absolutely fit the bill for promotion. As the judge will instruct you, your findings must be a preponderance of the evidence, which is just 51%. We submit that the evidence is way beyond 51% to answer every yes or no question on the verdict sheet. Yes, there was discrimination, or yes, there was a violation of the Whistleblower Act. We submit that when you do speak the truth in this verdict, you will speak up for what's right. You will follow the law. We thank you again.
Thank you, Attorney McDonough. Ladies and gentlemen, that portion of Attorney McDonough's closing argument that stated that the burden of proof is equated to 51% is struck from the record. I will be instructing you in detail as to the burden of proof that will govern the conduct of your deliberations. All right, very well. Ladies and gentlemen, that concludes closing arguments. It's time for your recess. We're going to take probably closer to 30 minutes or so as I put some final touches on my jury charge. A reminder that the jury charge will probably take around an hour and 20 minutes for me to read through. So whatever you need to do to liven yourselves up right now would certainly be appreciated. And while you will not have the written copies of the jury charge with you during the course of my oral reading of the jury charge, you will have it with you during the course of your deliberation, with the ongoing instruction not to discuss the case with anyone, most importantly not amongst yourselves, nor to do any investigation or research or look at any media reports. I'll see you in just about 20 to 30 minutes.
Your court is now back in session. Please be seated.
Okay. Mindful that you'll lodge your objections to the jury charge as well as the verdict slip after I have completed my charge. I've given you the revised jury charge. I'm not going to go through that. I do want to make sure, apart from substantive issues that I respect you will have, that in terms of the flow of questions and the verdict slip, they were all on the same page. I added question number 1, which was the overarching question. The problem, the difficulty with question number 1 is that if the jury answers yes, we find that there was discriminatory conduct during that time period,
then they might come to some number for damages. If they answer similarly yes to any one of questions 2, 3, and 4, which relate to the same time period, then they'll also come to another calculation of damages, which cannot be duplicative. Okay? And the way I address that is as follows. And here I'm simply looking for any constructive comment that relates to the flow of the questions. Okay? So number 1, did plaintiff prove that he was discriminated during the time period 2014-2015? If you answered yes, go to question 2. If you answered no, then go to question number 5, which takes us to 2018. Because if they answered no, there's no reason to go through the subsidiary parts. Okay? So, if they answered yes, then we have effectively what I had initially as questions 1, 2, and 3, and now questions 2, 3, and 4. I deleted so-called from the word short list. It's in quotes. And each one says go to the next question, yes or no. Then question 5 is the 2018. Question 6 is the 2020-21. Now here, after question 6, I said, if you answered yes to one or more of 1, 2, 3, 4, 5, or 6, then go to question 7, which is damages. If you answered no to each of 1, 2, 3, 4, 5, or 6, and go to question 9, which is Lieutenant Dodge. Okay? So if they go to question 7, then what amount of damages do you award Patrick Buchanan? And then here, this is what I put in, which I believe is clear. Any damages you award relating to the period September 2014 through October 2015, as set forth in questions 1, 2, 3, and 4, are limited to one amount for such time period. Okay? Which I believe should cover the issue of a potential duplication of damages. So, and then simply from there, there's the question about punitive damages. I don't think that needs to be altered. Then 9 and 10 were Lieutenant Dodge, and I made no changes to those. So, I could add to this well, I'll be instructing that 5 or 6 of them need to respond yes. Sometimes I'll put that into each relevant question. If 5 or 6 of you answered yes, then but they'll be instructed on that. So, okay. So, Attorney Ryan.
Yes, Your Honor. We had asked before you got to punitive damages, do the question 6 in our proposal, do the actions, conduct, or mission warrant the imposition of punitive damages?
Okay, hold on a second here. I don't think you're going to get an objection from that. Okay, so what you're proposing is a new question 7. Please repeat.
Do the actions, conduct,
Well, actually, did the plaintiff have to Buchanan prove by a preponderance of the evidence?
That would be new question 8.
Right, new question 8. Proved by a preponderance of the evidence that, go ahead.
he is entitled to an award of punitive damages.
Okay. Fair enough, I appreciate that. Okay. If yes, go to 8. If no, go to 9. Okay? Anything else? Okay, Attorney McDonough.
Mine is a non-substantive. On the very last question, Your Honor, the damages for Mr. Dodge, it says just plainly amount in numbers, amount in words. And in our last charge, we had talked about using the format that you see under question 7, which is lost back wages, amounts, numbers, no.
Yeah.
And then emotion. So just a
Right.
copy and paste of the set.
Right.
The entry from number 7.
Yep. Okay. Okay. We did do that. Okay.
And then the only last one would just be the nitpicky one, which is there's a heading at the very start that says Patrick Buchanan's claims.
Oh.
And then I think you could just strike that altogether. I mean, you don't do a separate heading for Mr. Dodge, but I think the questions are clear.
That's fine. Thank you. Okay, Attorney Keston, your thoughts, please.
As to number 1s, and then you have the subsequent questions, we need additional, at least one additional question. There would be an amount of wages if he wasn't promoted in 14 off the short list. That's one wages amount. If he wasn't promoted in 50, because it was at the assessment center, that's a different amount.
Right. That was, we talked about that at length. And what you all presented is what I have here, mindful that I've added number 1. And that is that when I said we talked about it at length, I expressed questions about it, that you were content with the way it stands. So I understand your...
Without number 1. You've now added number 1, which encompasses things that are not being asked about.
Okay, I respect that. Any other comments on the flow of the questions on the special jury verdict slip?
The flow, I mean...
Any other comments on the special jury verdict slip?
No.
Okay. I'm going to make the changes that the plaintiffs have requested. I'll be right back, and then we're going to do the charge.
Thank you, Your Honor.
Well, rise, please.
All right, welcome back. And thanks for your patience. I do appreciate it.
Adams County Superior Court is back in session. Please be seated.
All right. As I have inquired many times before, I will ask once again, has anything come to your attention which has affected your abilities to remain fair, to remain impartial? Seeing and hearing no affirmative responses. Well, ladies and gentlemen, as you're aware, as I've told you, I'm now going to offer you what we refer to as the jury charge. It's effectively my instructions as to the law that will govern the conduct of your deliberation. And so important are these instructions, and so important that I get them correct when I am delivering them to you, that I actually will be reading them to you. I will endeavor to bring as much life to them as possible, because I respect that listening to anyone, better yet me, go on for just about an hour and 10 minutes or so on matters pertaining to the law might be just a little dry. So please bear in mind that it is extremely important that you remain alert, that you listen attentively. And to that end, please don't just close your eyes because you're resting them, because I won't know whether or not you're just resting your eyes or whether or not you're asleep. Our rules are strict, and if a juror is falling asleep during the jury charge, that juror may need to be excused. Now, I don't think that's going to happen here. One of the things that I've learned to do is to, if I feel that you are beginning to doze off, and I respect that, it's difficult perhaps not to, then you may see me staring intently at you with a smile on my face. That's just my way of just making sure that you remain alert, okay? And sometimes I actually either have to ask a juror to come sidebar and say, were you sleeping? So I hope that I won't need to do that. I am going to give us a halfway point, a break, so to speak, while I ask you all just to stand up and stretch, get the blood flowing. That's not a cue to talk amongst yourselves. Not that you've been doing that at all. You certainly have not. But simply just to stand up and stretch. Okay? And so having said all that, let's begin. Members of the jury, now that the evidence in the case has been presented and you have heard the closing arguments of the attorneys, the time has come for me to instruct you on the law, and my instructions will be in three parts. First, instructions on general rules that define and control the duties of a jury in a civil case. Second, instructions on the rules of law specific to this case. That is what Mr. Buchanan and Mr. Dodge must prove to make their cases. And third, some rules and guidelines for your deliberations. Part 1, general instructions. It is your duty to find the facts based solely on the evidence in this case and to render a true and just verdict based on the facts and the law. I will now tell you what the law is, and it is your duty as jurors to follow the law as I give it to you, regardless of whether you personally agree with the law or not. In following my instructions concerning the law, you must follow each instruction. You may not follow some and ignore others. All are important. Burden of proof. First, I want to discuss with you what is known as the burden of proof, or the standard of proof. The standard of proof in a civil case is that a plaintiff, such as Mr. Buchanan or Mr. Dodge, must prove his case by a preponderance of the evidence. This is a less stringent standard than is applied in a criminal case where the prosecution must prove its case beyond a reasonable doubt. By contrast, in a civil case such as this one, Mr. Buchanan and Mr. Dodge are not required to prove their cases beyond reasonable doubt. The party bearing the burden of proof in a civil case meets the burden when he shows the matter sought to be proved to be true by a preponderance of the evidence. The standard of a preponderance of the evidence means the greater weight of the evidence. A preponderance of the evidence is such evidence which, when considered and compared with any opposed to it, has more convincing force and produces in your minds an actual belief that what is sought to be proved is more probably true than not true. A proposition is proved by a preponderance of the evidence if, after you have weighed the evidence, that proposition is made to appear more likely or more probable in the sense that there exists in your minds an actual belief in the truth of that proposition derived from the evidence, notwithstanding any doubts that may still linger in your minds. Simply stated, a matter has been proved by a preponderance of the evidence if you determine, after you have weighed all the evidence, that the matter is more probably true than not true. Stated another way, if you would put all the credible evidence on opposite sides of a pair of scales, Mr. Buchanan and Mr. Dodge must produce enough evidence to make the scales tip in his favor. If Mr. Buchanan or Mr. Dodge fails to do so, you must return a verdict for the defendants. You are not under any duty to decide what the truth of a particular matter is if Mr. Buchanan or Mr. Dodge did not introduce enough evidence on the point to satisfy you, or if to do so, you would need to speculate, guess, or simply choose arbitrarily. Indeed, for you to do that would be a breach of your sworn duty to decide the case on the basis of the evidence rather than on the basis of speculation. If on all of the evidence it is just as reasonable to support that the city of Greenfield and Mr. Hague did not suspend, demote, and or fail to promote Mr. Buchanan because of his race, then Mr. Buchanan has failed to make his case, and you must enter a finding in favor of the city of Greenfield and Mr. Hague. Likewise, if on all the evidence it is just as reasonable to suppose that the city of Greenfield did not investigate and place Mr. Dodge on administrative leave because of protected activity, then Mr. Dodge has failed to make his case, and you must enter a finding in favor of the city of Greenfield. Evidence. Next, I want to discuss with you generally what we mean by evidence and how you should consider it. While you must follow the law as I give it to you, you are the judges of the facts and must find the facts. In determining the facts, you must rely solely on the evidence admitted in this case. What is evidence? It falls into two categories. First, It is the sworn testimony of the witnesses, whether given during direct or cross-examination. Second, it is the exhibits that were admitted into evidence during the trial. Let me also tell you what is not evidence. The opening statements and closing arguments of the attorneys are not evidence, nor are any other arguments they may have made during the course of the trial. Questions asked of the witnesses are not evidence. They may be considered only to the extent that they gave meaning or context to the answers to those questions by the witnesses. An unanswered question is not evidence. Any answer or comment that I ordered stricken is not evidence. Anything you may have seen or heard outside of the courtroom is not evidence. If you did not see it or hear it in the courtroom during the trial, it is not evidence and may not be considered. If you kept notes, those notes, of course, are not evidence. They may be used simply as an aid to refresh your own memory of the evidence that was presented during the course of the trial. Since you will not have access to any transcript of the testimony, your notes may be helpful in that regard. During the trial, I permitted A for identification to be marked as a chalk. The chalk is a party's description to describe something involved in this trial. You may grant the chalk as much or as little weight in your deliberations. If your recollection of the evidence differs from the chalk, rely on your recollection. I have allowed you to hear evidence that at one point in time a Confederate battle flag was hanging in a garage partially owned by then Greenfield Police Sergeant Daniel McCarthy. I have since reconsidered my ruling and determined that such testimony is not relevant to any issues in this case and should not have any effect on the findings you are being asked to make in this case. You are not to consider such testimony in any manner whatsoever. Now that we have examined what evidence is, let me move on to how you should evaluate that evidence. You must determine the weight, what importance to give to the different evidence before you. The law does not give oral testimony any greater or lesser weight than documentary evidence. You may find that the credible testimony of a particular witness is very important in reaching a factual finding, or you may find that a document admitted into evidence is more important. The weight of the evidence need not depend on the sheer volume of evidence or the number of witnesses or exhibits. It's up to you, using your intelligence, life experience, and common sense to evaluate all of the evidence. There are two types of evidence that you may use to determine the facts of the case: direct evidence and circumstantial evidence. Direct evidence is when a witness testifies about the fact to be proven based on what he or she claims to have seen or heard or felt with his or her own eyes, ears, or hands. Circumstantial evidence is when evidence offered as to a fact or facts invites a reasonable inference about a fact that is to be proved. An inference is a permissible deduction that you may make from evidence you have accepted as believable. Drawing inferences is something you do every day. You make little steps in reasoning in which you take some known information, apply your intelligence, life experience, and common sense to it, and then draw a conclusion. Let me give you an example. Suppose you wake in the morning, and even though the day is bright and clear, you see puddles of water on the sidewalk and street. If you had seen or heard the rainfall during the night, which would be direct evidence that it had rained. However, even if you had slept so soundly you had neither seen nor heard the rain, you could still conclude that it had in fact rained. The fact of rain is a reasonable inference that can be drawn by the presence of water. An inference can be drawn, however, only if it is reasonable and logical. If you saw water only on your street and sidewalk, but not any other street in the neighborhood, other facts, such as broken water pipe, might explain the presence of water, but rain would not be a reasonable inference under those circumstances. The law allows both direct and circumstantial evidence and does not prefer one over the other. Both types of evidence, if credible, can form the basis of your verdict. Now, just as I told you how to evaluate the evidence, I shall also tell you how you shall not evaluate the evidence. You shall not be swayed by prejudice, bias, sympathy, or anger, or by whether your verdict will please or disappoint any person connected with this case. Nor shall you be influenced by any personal likes or dislikes you may have come to feel toward any party or attorney. This case should be decided by you as an action between parties of equal standing in the community, of equal worth, and holding the same or similar stations in life. In this courtroom, every party is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. Further, you're not to consider anything I may have done or said as reflecting any opinion as to how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it, for it is utterly irrelevant. Indeed, guesswork, conjecture, and assumptions of any kind must play no role whatsoever in your decision. Your decision must rest squarely on the evidence. Credibility of witnesses. It will be your duty to decide any disputed questions of fact. You will have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses. And if there are any conflicts in the testimony, it is your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says, or only part of it, or none of it. Disbelief of a witness's statement is not affirmative evidence of the opposite proposition. When you disbelieve a witness, it just means you have to look elsewhere for credible evidence concerning that issue. In deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence drawing on your own common sense and experience of life. Often it may not be what a witness says, but how he or she says it that might give you a clue whether or not to accept his or her versions of an event as believable. You may consider a witness's character, his or her appearance and demeanor on the witness stand, his or her frankness or lack of frankness in testifying, whether his or her testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity he or she had to observe the facts by which he or she is testifying, the degree of intelligence he or she shows, whether his or her memory seems accurate. In assessing the testimony of a witness, you may consider his or her motive for testifying, whether he or she displays any bias in testifying, and whether or not he or she has any interest in the outcome of the case. However, the fact that a witness may have some interest in the outcome of this case does not mean that a witness is not trying to tell you the truth as that witness recalls it or believes it to be. But the witness's interest is a factor that you may consider along with all the other factors. The weight of the evidence on each side does not necessarily depend on the number of witnesses testifying for one side or the other. You're going to have to determine the credibility of each witness who has testified and then reach a verdict based on all the believable evidence in the case. Where there are inconsistencies or discrepancies in a witness's testimony or between the testimony of different witnesses, that may or may not cause you to discredit such testimony. Innocent mistakes of memory do happen. Sometimes people forget things or get confused or remember an event differently. In weighing such discrepancies, you should consider whether they involve important facts, or only minor details, and whether the discrepancies result from innocent lapses of memory or intentional falsehoods. When you evaluate how reliable a witness's testimony is, you may take into account whether that witness made an earlier statement that differs in any significant way from his or her present testimony at trial. It is for you to say how significant any difference is. If a witness's earlier statement is not consistent with his or her present testimony, you may take that into account when you determine how much belief to give that person's testimony from the witness stand. Deposition testimony. A deposition is testimony that was given out of court by a witness under oath in response to questions asked by either of the attorneys. You are to treat a deposition in the same way as if the testimony had been given in court. As with all witnesses, it is for you to determine how believable and how significant that testimony is. Prior inconsistent statement. A witness who testifies during the course of a trial may be discredited or impeached by contradictory evidence or by evidence that at some time before the trial the witness has said or done something that is inconsistent with the testimony the witness gave while on the witness stand in this trial. You are not required to believe or disbelieve a witness because his or her testimony has or has not been impeached or contradicted in that way. It is for you and you alone to decide the believability of all testimony of witnesses and to give the testimony of each witness such weight, if any, as you believe that testimony deserves. In evaluating a witness's credibility, you may consider whether any prior statement of the witness was in any significant way inconsistent with the witness's testimony at trial. It is up to you to say how significant any inconsistency is and how any such inconsistency affects your evaluation of credibility. As I have explained, however, any such prior statement is to be considered only as to the witness's credibility. You may not consider any prior statement as, in and of itself, proof of any fact contained in it. Implicit bias. Let's turn to another important issue that I raised with you at the beginning of this trial. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair. I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problem, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all of the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Reprimand of counsel. During the course of this trial, I have had occasion to admonish or reprimand an attorney. You are to draw no inference against him or his clients because of that. It is the duty of the attorneys to offer evidence, to object, and to argue to you on behalf of their side. It is my function to exclude evidence or argument that is inadmissible under our rules and to admonish attorneys when I feel that is necessary for an orderly trial. But you should draw no inference from that. It is irrelevant whether you like a lawyer or whether you disbelieve or you believe I do or don't like a lawyer. The issue is not which attorney is more likable. In fact, in this case, I'd like to express my thanks to each of the attorneys for their conscientious efforts on behalf of their clients and for the assistance that they have given me during this trial. Your verdict must be based solely on the facts as you find them from the evidence and on the laws I explained it to you. Nothing else that may have happened in this courtroom is relevant to the truth of your verdict. Part 2, specific instructions. Everything I have said thus far constitutes general rules that apply to all civil cases. Now I will instruct you on the law of the particular claims brought by Mr. Buchanan and Mr. Dodge in this case. In this case, Mr. Buchanan claims that the City of Springfield and Mr. Hague discriminated against him in violation of General Laws Chapter 151B by suspending, demoting, and failing to promote him because of his race and retaliated against him in violation of Chapter 151B for bringing and maintaining this lawsuit. The city of Greenfield and Mr. Hague deny that they suspended, demoted, or failed to promote Mr. Buchanan because of his race or retaliated against him for bringing and maintaining this lawsuit. Mr. Dodge claims that the city of Greenfield retaliated against him in violation of General Laws Chapter 149, Section 185, by investigating him and placing him on administrative leave because he engaged in protected activity. The city of Greenfield denies that it retaliated against Mr. Dodge. It will be your duty, members of the jury, to determine whether Mr. Buchanan and Mr. Dodge have proven each of the elements of their claims against the city of Greenfield on Mr. Hague by a preponderance of the evidence. Mr. Buchanan's claims: discrimination based on race. Introduction. The primary Massachusetts anti-discrimination statute makes it unlawful for an employer or its agents to refuse to hire or promote or to discharge or discriminate in compensation, terms, conditions, or privileges of employment based on a person's race. Part B. Plaintiff's burden of proof. Mr. Buchanan was an employee of the city of Greenfield. Mr. Buchanan claims that the city of Greenfield and Mr. Hague discriminated against him on the basis of his race. Specifically, the plaintiff claims that the city of Greenfield and Mr. Hague suspended, demoted, and failed to promote him because of his race. In order to prove a claim for discrimination, Mr. Buchanan must show 4 elements: membership in a protected class, adverse employment action, discriminatory animus, and causation. As for causation, the plaintiff must prove to you by a preponderance of the evidence that the defendants discriminated against him and that discriminatory animus was the determinative cause of the defendant's decisions to suspend, demote, and not to promote Mr. Buchanan. The discriminatory animus was determinative if it was a material and important reason that the defendants took adverse action with respect to the plaintiff's employment. The burden of proof rests with Mr. Buchanan at all times, unless I instruct you otherwise. Motive, intent, or state of mind. In this case, one critical issue is why the defendants suspended, demoted, and did not promote Mr. Buchanan. It is unlawful to suspend, demote, or fail to promote a person because of his race. It is not unlawful to suspend, demote, or fail to promote a person for a legitimate reason. To decide this case, you will have to inquire into and determine the defendant's motive, intent, or state of mind. Direct evidence. Sometimes motive, intent, or state of mind can be proved directly. Direct evidence is evidence that, if believed, would result in a highly probable inference that a forbidden bias was present in the workplace. Examples of direct evidence include facially discriminatory employment policies, statements of a defendant that suggest a discriminatory attitude toward black individuals, or testimony of a witness about what a witness said that would be reflective of his state of mind. Circumstantial evidence. Motive, intent, or state of mind may be proved indirectly or circumstantially. You may examine the defendant's actions and words and all the surrounding circumstances to help you determine what their motive, intent, or state of mind was when they suspended, demoted, and did not promote Mr. Buchanan. The law does not dictate any distinction between the weight to be given direct or circumstantial evidence. That is up to the jury. Circumstantial evidence permits you to draw reasonable inferences from facts in evidence. The inference proposed from the evidence need only be reasonable. It need not be the only one possible. Unexamined bias. Discriminatory animus can be established even if an employer is not aware of his or her bias. Employment decisions that are made because of stereotypical thinking about people because of their race, whether conscious or unconscious, violate the Massachusetts law prohibiting discrimination. Stereotypical thinking occurs when an employer categorizes people on the basis of broad generalizations. Statements made by the defendants as reflecting stereotypical thinking, categorizing people on the basis of broad generalizations, when considered with other evidence of disparate or unfair treatment, may lend support to the contention that the adverse employment action was made on an impermissible basis. For example, if the performance of an employee, male or female, suffers as a result of family responsibilities or any other personal obligation or interest, the employer is free to respond accordingly. However, an employer is not free to assume that a woman, because she is a woman, will necessarily be a poor worker because of family responsibilities. Proving discrimination by circumstantial evidence. Pretext. Circumstantial evidence of discrimination can include proof that the reason given by the City of Greenfield and Mr. Hague for suspending, demoting, and not promoting Mr. Buchanan is not true, or if more than one reason was given for suspending, demoting, and not promoting Mr. Buchanan, that at least one of the reasons given was not true. Categories of circumstantial evidence demonstrating pretext include conflicting performance evaluations, stereotypical thinking by the employer or those in charge, and not following written procedures with regards to the adverse action taken. The most probative means of assessing discriminatory intent is by examining whether comparators, other employees who were similarly situated in terms of performance, qualifications, and conduct, but who were not within the protected class, were treated differently. Other indications of pretext can support a conclusion that a proffered reason is pretextual, including an employer's shifting explanation for its adverse action. This inference is allowable because experience indicates that people do not generally act in a totally arbitrary manner without any underlying reasons, especially in a business setting. In a situation where the legitimate reason or reasons advanced by the employer for taking an adverse action are rejected as not being the true reasons, one can reasonably conclude that the employer based its decision on impermissible consideration. When considering pretext, your focus must be on the defendant's state of mind, not on whether their reasoning was right or wrong, or whether their business judgment was sound or unsound. Evidence of pretext standing alone may but need not support an inference of unlawful bias. Therefore, if the plaintiff has persuaded you that at least one of the City of Greenfield and Mr. Hague's reasons is false, you may, but are not required to, infer that the City of Greenfield and Mr. Hague are covering up a discriminatory intent, motive, or state of mind. Ladies and gentlemen, we are halfway there. You're doing a great job listening. Time to stand up and stretch for a brief moment. Remarks that support an inference of bias. Discrimination can be inferred from statements reflecting a bias. However, in determining the persuasiveness of those statements on the issue of the defendant's bias, the law requires you to consider not only the statements, but the context and circumstances in which they were made. Subjective criteria. Unlawful bias may be inferred from evidence that the employer used subjective criteria in making employment decisions. Employer's failure to follow policy or guidelines. Unlawful bias may be inferred from an employer's failure to follow its own policies or guidelines in making the employment decision involved in this case. Employer's failure to follow the law. An unlawful bias may be inferred from an employer's failure to follow the law with respect to employment decisions involved in this case. Business judgment. When assessing a plaintiff's claim of pretext, you should focus on the motivation of the employer and not the soundness of its business judgment. The anti-discrimination laws are not a general civility code. They do not require an employer to provide a stress-free workplace. The law protects people against unlawful discrimination. It does not protect against all instances of arbitrary action or from poor managerial judgment. Courts and juries do not sit as super personnel departments assessing the merits or even the rationality of employers' non-discriminatory business decisions. Workplaces are rarely idyllic retreats, and the mere fact that someone is displeased by an employer's act or omission or is treated unfairly does not make it actionable. While an employer's judgment or course of action may seem poor or erroneous to outsiders, the relevant question is simply whether the given reason was a pretext for illegal discrimination. The employer's stated legitimate reason must be reasonably articulated and non-discriminatory, but does not have to be a reason that you, the jury, would act on or approve. An employer's reasons for its decision may be unsound or even absurd, but if they are neither discriminatory nor proven as pretext, the plaintiff cannot prevail. You may consider the reasonableness or lack of reasonableness of the defendant's stated business judgment, along with all the other evidence in determining whether the defendants discriminated against the plaintiff. The reasonableness of the employer's reasons may, of course, be probative of whether the reasons are pretexts. You must keep in mind, however, that your focus is to be on the defendant's motivation and not on the soundness of their business judgment. Mixed motive. Sometimes employment decisions are made based on a mixture of non-discriminatory and discriminatory reasons. Here, Mr. Buchanan has asserted that discriminatory bias was at least one factor motivating the defendant's decisions to suspend, demote, and not promote him. Mr. Buchanan need not prove to you that his race was the sole reason for the adverse employment action. Rather, the defendants must prove by a preponderance of the evidence that they would have made the same decision regardless of the plaintiff's race. If you are not convinced that the defendants would have taken the same action regardless of the plaintiff's race, and you are convinced that the plaintiff has proven that the claimed discriminatory reason was determinative of the action, then you must return a verdict for the plaintiff. Retaliation, Chapter 151B, Introduction. Protection against retaliation is intended to protect individuals from discrimination motivated, at least in part, by a distinct intent to punish or to rid a workplace of someone who complains of unlawful practices. The plaintiff does not need to establish the underlying discrimination in order to prove retaliation. Prima facie case of retaliation where plaintiff opposed employer's discriminatory practices. Mr. Buchanan claims that Mr. Hague in the city of Greenfield retaliated against him because he opposed a discriminatory practice. In order to recover, Mr. Buchanan must prove to you by a preponderance of the evidence the following elements. 1. Mr. Buchanan reasonably and in good faith believed that Mr. Hague and the city of Greenfield were engaged in wrongful discrimination. 2. Mr. Buchanan acted reasonably in response to that belief in opposing Mr. Hague and the city of Greenfield's practice. And 3. Mr. Hague and the city of Greenfield's retaliatory motive was a determinative factor in the decision to affect Mr. Buchanan's terms and conditions of employment. Retaliatory motive was determinative if it was a material and important reason that Mr. Hague and the city of Greenfield took adverse action with respect to Mr. Buchanan's employment. Prima facie case of retaliation where plaintiff filed a complaint, testified, or assisted in a Massachusetts Commission Against Discrimination, MCAD, or court proceeding. Mr. Buchanan claims that Mr. Hague and the city of Greenfield retaliated against him because he filed complaints alleging race discrimination and retaliation with Massachusetts Commission Against Discrimination and filed this lawsuit. To recover, Mr. Buchanan must prove to you by a preponderance of the evidence the following evidence. 1. He engaged in protective activity by filing a complaint. 2. Mr. Hague and the city of Greenfield were aware of these activities. 3. Mr. Hague and the city of Greenfield thereafter took an adverse employment action against Mr. Buchanan. And 4. But for Mr. Buchanan's protected activity, Mr. Hague and the city of Greenfield would not have taken the adverse employment action against him. Adverse employment action defined. In order for Mr. Buchanan to establish that he suffered an adverse employment action, he must prove to you by a preponderance of the evidence that he has been materially disadvantaged in respect to salary, grade, privilege, or other objective terms and conditions of employment. A threat, including a threat to act adversely to the employee, may also itself be an adverse employment action. Subjective feelings of disappointment or disillusionment concerning an employment action do not constitute an adverse employment action. Retaliation and temporal proximity. You are permitted to infer Okay. If everyone can just keep looking up, that would be helpful. Okay. If you turn your head down, I can't tell whether or not you are with us. Okay. Thank you. Retaliation and temporal proximity. You are permitted to infer retaliation from the timing and sequence of events. The inference may be drawn if adverse action is taken against a satisfactorily performing employee in the intermediate aftermath of the employer's becoming aware of the employee's protected activity, or where adverse employment actions follow close on the heels of protected activity. In other words, close temporal proximity between the protected activity and the adverse employment action permits an inference of the causal nexus necessary for a finding of retaliation. However, it is not permissible to draw an inference of retaliation where adverse employment actions or other problems with an employee predate any knowledge that the employee has engaged in protected activity. Part 3. Damages. Generally. The fact that I am instructing you on damages is not an indication by me that I believe you should reach the question of damages or that any damages are appropriate. I am merely providing you now with all the law you may need to render a complete verdict in the event you reach that issue. If Mr. Buchanan has proven to you that the City of Greenfield and Mr. Hague unlawfully discriminated against him and or retaliated against him, then you must decide the amount of damages, if any, that will fairly compensate him. The purpose of an award of compensatory damages is to make the plaintiff whole for all the losses that he has suffered because of the defendant's unlawful discrimination and or retaliation. Except where I instruct you otherwise, Mr. Buchanan bears the burden of proof on damages. Although uncertainty in the amount of damages does not bar recovery and mathematical precision is not required, you must not speculate, conjecture, or guess in awarding damages. The award is acceptable as long as it is based on just and reasonable inferences from the evidence. If you find that the defendants unlawfully discriminated against the plaintiff, then you may award damages in the following 3 areas: back pay, emotional distress, and punitive damages. I'll explain each to you. You may award damages in each area, but you must avoid a duplication or double counting of any elements of damages. Back pay. The plaintiff is entitled to back pay, which is the amount of the plaintiff's lost earnings from the date of the adverse employment decision until today. This includes all lost salary, bonuses, the value of employment benefits, and health insurance benefits that would have accumulated but for the defendant's discriminatory or retaliatory conduct. Emotional distress. If you find that Mr. Buchanan has been discriminated or retaliated against, you may also award him reasonable damages for his emotional distress. Emotional distress includes mental pain, discomfort, indignity, depression, fear, anxiety, or humiliation suffered as a result of the discrimination. Although uncertainty in the amount of damages does not bar recovery and mathematical precision is not required, you must not speculate, conjecture, or guess in awarding damages. When considering emotional distress awards, evidence in the form of some physical manifestation of the emotional distress is not necessary to awarding damages. An award must rest on substantial evidence, and its factual basis must be clear on the record. Some factors that you should consider include, but are not limited to, the nature and character of the harm, of the alleged harm. 2, the severity of the harm. 3, the length of time the plaintiff has suffered and reasonably expects to suffer. And 4, whether the plaintiff has attempted to mitigate the harm, e.g. by counseling or by taking medication. In addition, the plaintiff must show a sufficient causal connection between the defendant's unlawful act and the plaintiff's emotional distress. Punitive damages. If you find that the City of Greenfield has intentionally discriminated against Mr. Buchanan, you may consider whether punitive damages are warranted. Punitive damages are different from compensatory damages. Unlike compensatory damages, which compensate the victim for the harm he has suffered, The purpose of punitive damages is to punish the defendant for conduct that is outrageous because of the defendant's evil motive or reckless indifference to the rights of others. To find that punitive damages should be awarded, you must find that more than intentional discrimination occurred. Punitive damages may be awarded only where the defendant's conduct is outrageous or egregious. In determining the amount of punitive damage award, if any, you should consider 1. The egregious or outrageous character or nature of the City of Greenfield's conduct. 2. The City of Greenfield's wealth, in order to determine what amount of money is needed to punish the City of Greenfield's conduct and to deter any future acts of discrimination. 3. The actual harm suffered by the plaintiff. And 4. The magnitude of any potential harm to other victims if similar future behavior is not deterred. 5. Whether there was a conscious or purposeful effort to demean or diminish the class of which Mr. Buchanan is a part, or Mr. Buchanan because he is a member of that class. 6. Whether the City of Greenfield was aware that the discriminatory conduct would likely cause serious harm or recklessly disregard the likelihood that serious harm would arise. 7. The City of Greenfield's conduct after learning that the initial conduct would likely cause harm. And 8. The duration of the wrongful conduct and any concealment of that conduct by the City of Greenfield. If you do award punitive damages, you should fix the amount by using calm discretion and sound reason. Time to stand and stretch once again. I'm on page 22 of 31. We're almost there, ladies and gentlemen. Part B, Mr. Dodge's claim, government retaliation against its employee, the Whistleblower Act. Massachusetts law prohibits a governmental employer from retaliating against its employee for engaging in certain types of activity. Mr. Dodge has sued the City of Greenfield, his government employer, for unlawful retaliation in violation of the Whistleblower Act. The parties agree that the City of Greenfield is a government body covered by this law. To prove his claim, Mr. Dodge must show that 3 things are more likely true than not true. 1, Mr. Dodge engaged in protected activity while working as a government employee of the City of Greenfield. 2, the City of Greenfield retaliated against Mr. Dodge because of that protected activity. And 3, the City of Greenfield's retaliation harmed Mr. Dodge. I will now describe each of these 3 items in a little more detail. Protected activity. First, Mr. Dodge must prove that he engaged in activity protected by this law. In the circumstances of this case, Mr. Dodge must show that the following things are more likely true than not true. While working as an employee of the City of Greenfield, Mr. Dodge disclosed or threatened to disclose to a supervisor or to a government agency or public body an activity, policy, or practice of the City of Greenfield that Mr. Dodge reasonably believed either violated a law or posed a risk to public health, safety, or the environment. For activity that was a disclosure to an outside government agency to be protected activity, Mr. Dodge must also prove that he notified a supervisor about the activity, policy, or practice in writing and allowed the City of Greenfield a reasonable opportunity to correct the activity, policy, or practice before reporting the matter to an outside government agency. However, Mr. Dodge need not provide this written notice if at least one of the following conditions existed. If Mr. Dodge was reasonably certain that one or more supervisors at the City of Greenfield knew about the activity, policy, or practice, and the situation was an emergency, or if Mr. Dodge reasonably feared physical harm as a result of the disclosure, or if Mr. Dodge's disclosure concerned what Mr. Dodge reasonably believed to be a crime, and he made that disclosure to a court, a grand jury, or trial jury, or to a prosecutor or police officer. Mr. Dodge may also show that he engaged in a protective activity by showing that the following things are more likely true than not true. While working as an employee of the City of Greenfield, Mr. Dodge provided information to or testified before a public body conducting an investigation into an activity, policy, or practice of the City of Greenfield that Mr. Dodge reasonably believed either violated a law or posed a risk to public health, safety, or the environment. Mr. Dodge does not need to prove that the government conduct that he testified about or provided information about actually violated a law. Mr. Dodge need prove only that he reasonably believed that the conduct violated a law or posed a risk to public safety, public health, safety, or the environment. For purposes of this case, if Mr. Dodge reasonably believed that the conduct violated General Laws Chapter 151B, that meets this requirement. Mr. Dodge may also show that he engaged in protective activity by showing that the following things are more likely true than not true. While working as an employee of the City of Greenfield, Mr. Dodge objected to or refused to participate in an activity, policy, or practice that Mr. Dodge reasonably believed either violated a law or posed a risk to public health, safety, or the environment. Reasonable belief. Mr. Dodge does not need to prove that the government conduct that he objected to or refused to participate in actually violated a law. Mr. Dodge need prove only that he reasonably believed that the conduct violated a law or posed a risk to public health, safety, or the environment. For purposes of this case, if Mr. Dodge reasonably believed that the conduct violated General Laws Chapter 151B, that belief meets this requirement. Reasonably believed has two parts. First, Mr. Dodge himself must have actually held that belief, and second, an objective, ordinary person would have thought that Mr. Dodge's belief was reasonable based on all the facts and circumstances. Retaliation. The second thing that Mr. Dodge must prove is that the City of Greenfield retaliated against him because he engaged in the protected activity. Retaliation means that the City of Greenfield discharged, suspended, or demoted Mr. Dodge or took other adverse action against him concerning the terms and conditions of his employment, and did so because Mr. Dodge engaged in the protected activity. Mr. Dodge must prove that the City of Greenfield's desire to retaliate against him for engaging in protective activity was a real factor in the City of Greenfield's decision to treat him adversely. Mr. Dodge need not prove that his protected activity was the only reason for the City of Greenfield's action against him, but Mr. Dodge must prove that his protected activity is what made the difference in how the City of Greenfield treated him. In other words, Mr. Dodge must prove that the City of Greenfield would not have treated him adversely unless he had engaged in the protective activity. Juries do not sit as super personnel departments assessing the merits or even the rationality of employers' non-retaliatory business decisions. The law protects against unlawful retaliation. It does not protect against shabby or unfair actions against an employee not made because the employee engaged in protected activity. Harm suffered by Mr. Dodge. Third, Mr. Dodge must prove the damages, meaning dollar value of the injury that he suffered because the City of Greenfield retaliated against him for engaging in protected activity. If Mr. Dodge proves this claim, you should award an amount of money that will fairly compensate him for losses incurred because of the City of Greenfield's conduct. The purpose is not to reward Mr. Dodge, and it is not to punish the City of Greenfield. Mr. Dodge must prove, more likely than not, what the nature and amount of the damages are. For example, if you find that the City of Greenfield reduced Mr. Dodge's wages in retaliation for engaging in protected activity, you may award Mr. Dodge back pay for the amount of the wage reduction proved by Mr. Dodge. Likewise, if you find that the City of Greenfield's conduct caused Mr. Dodge emotional distress, you may award him emotional distress damages in an amount proven by Mr. Dodge. I have already explained back pay and emotional distress damages to you. Sometimes there is an element of uncertainty in putting a dollar value on the amount of harm suffered by a plaintiff. That does not necessarily prevent you from awarding full and fair compensation as long as the evidence makes it possible for you to determine the amount in a reasonable manner. We leave that amount to your judgment as members of the jury. You may not determine Mr. Dodge's damages or harm suffered by mere guesswork, but it is enough if the evidence allows you to draw fair and reasonable conclusions about the extent of the harm. Part 3, instructions on deliberations. That concludes my instructions to you on the law that applies to the issues raised in this case. Let me turn to the third part of my instructions, which are general instructions for your deliberations. The first matter is the appointment of a foreperson for the jury. I now appoint juror number 11 in seat number 2 as foreperson. Now, being foreperson carries with it neither more honor nor more pay. You are all equal in your voices and your votes as jurors in this case, and you should all be active participants in your deliberations. The foreperson has 2 important functions, however. First, the foreperson facilitates, that is, helps organize and acts as a moderator of the discussions among the jurors during your deliberations. The foreperson should try to ensure that the deliberations proceed in a fair and orderly manner, that every juror has an opportunity to participate, and you all listen carefully and patiently to the views of each other. Second, the foreperson will fill out the verdict slip on behalf of the entire jury when you have reached your verdict, and will report your verdict in open court on behalf of the jury. Next, let me note that although our electronic recording system has recorded all that was said and done during the trial, we do not have the capacity to give you transcripts of the evidence. So again, let me emphasize to you that you will have to rely on your memory of the testimony of the witnesses in reaching your verdict, perhaps assisted by such notes as you may have taken. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. In other words, you cannot talk to anyone on the phone, correspond with anyone, or electronically communicate with anyone about this case. You can only discuss the case in the jury room with your fellow jurors during deliberations. I expect that you will inform me as soon as you become aware of another juror's violation of these instructions. When you deliberate in the jury room, set things up so that each and every one of you can fully and fairly express your opinion about the particular question you're talking about. Deliberate all together, not 2 or 3 of you having a side conversation. You all need the benefit of each other's input. It is probably not a good idea to take an initial vote at the outset of your deliberations. If you do take a straw vote, you may end up cutting off discussion, which would defeat one of the purposes of having a jury of 6 people. If you hear all 6 of your points of view before voting, you may well increase your ability to summon all the wisdom, judgment, and conscience that you possess in reaching your verdict in this case. In general, the jurors may only discuss the case and deliberate when all members of the jury are in the deliberation room. If, for example, a juror is using the restroom, you must cease deliberations. Please understand that this is an absolute prohibition. Once all of the deliberating jurors have reconvened, you may recommence your deliberations. Reaching a verdict is not necessarily going to be an easy task. It will require conscientious service on your part, a conscientious approach to your duty as jurors. I trust that that you will each approach the deliberations with mutual respect for the opinions of your fellow jurors, that you'll have a disposition to listen to each other and to be convinced as to one another's arguments and persuaded as to one another's views. If you have a strong view about any aspect of this case, no one suggests that you surrender it, but you deliberate together to see whether the views of other jurors do affect your views of the matter. Bear in mind that you are not partisans, you are not advocates, you are judges of the facts, and that truly is an important responsibility. Remember that your verdict must be based solely on the evidence and the law as I have given it to you in these instructions. This case has taken a great deal of time and effort to prepare and try. There is no reason to think that it could be better prepared or tried, or that another jury would be better qualified to decide it. It is important, therefore, that you reach a verdict if you could do so conscientiously.
Unlike a criminal case in which the verdict must be unanimous, in this case, because it is a civil case, the agreement of any 5 of the 6 jurors is sufficient for a verdict. Now, you will have with you what is referred to as a special jury verdict. I'll briefly explain that form to you because it is self-explanatory. The form, which comprises 4 pages, has a series of questions that are followed by instructions. For example, if you answer yes to question 1, go to question number 2. If you answer no to question 1, then go on to question number 5. You are to follow those instructions strictly. Please pay particular heed to the instructions that will appear after question number 6. Okay? Please read them carefully. Now, as to each of the questions that are posed, 5 of the jury members of the jury must agree on the answer, but it need not be the same 5 jurors each time. Ms. Foreperson, when the jury has reached a verdict on each required question, you will fill in the appropriate answers, sign and date the verdicts up, and inform the court officer that the jury is ready to return to the courtroom. When we are assembled in the courtroom, the clerk will ask the jury's answer to the appropriate questions, and you will respond on behalf of the 5 or more jurors who have agreed on the answer. The other jurors will be asked to collectively confirm the answer. Questions for the court? If during the course of your deliberations you should have a question about the law or about my instructions to you on the law, and by telling you this, I'm not suggesting you'll have one, you should do the following. First, agree on the form of the question and have the foreperson write it down on a piece of paper. The foreperson should give the note to the court officer who will bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it. I'll then either ask you to return to the courtroom and answer the question orally in court, or if appropriate, I may write my answer out and send that answer back to you in the jury room. If it should become necessary to communicate with me on any matter during your deliberations, I ask that you do so only in writing through a note, and I'll respond to it. Except for your fellow deliberating jurors, you are instructed not to talk to anyone about any aspect of the merits of this case during your deliberations. There have been audio recordings submitted as evidence in this case. If you wish to listen to the recordings, please have the foreperson write the request down on a piece of paper. The foreperson should give the note to the court officer who will bring it to me. I'll call the lawyers together, and we will bring you back into the courtroom and play for you any audio recordings that you wish to hear that has been entered into evidence. Members of the jury, there is no prescribed limit or pace to your deliberations. That is entirely up to you. We ask only that you give full, fair, and thorough consideration to the evidence in reaching your verdict in this case. The court day usually ends around 4:15. Thus, I will, if you've not reached the verdicts, suspend your deliberations for the day, ask you to stop those deliberations. We'll bring you back the next court day at 9 a.m., and you may resume your deliberations at that time. Now, I'm about to submit this case to you. The exhibits will be with you in a few moments, and 4 full copies of my instructions will be with you. Members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning in the fullest discharge of your oaths as jurors. Okay? I will now have the clerk swear in the court officers who will be escorting you to your deliberations. Let's swear them in, then I'll see counsel at sidebar.
Please raise your right hands to be sworn. You swear that you will keep this jury in some convenient place until they shall be agreed. That you will not suffer any person to speak to them or speak to them yourself unless by order of the court or to ask if they...
He was demoted. Somebody had a question on that. If you get 2, 3, and 4, if those are no and one's a yes, it's going to be no problem. Of course, they're going to vote on that and everything.
Okay. Anything further? Okay. Your objections are noted. Okay. All right. Now,
Ladies and gentlemen, a few additional comments, then I'll send you on your way. I'm adding to the section relative to prior inconsistent statements. Statements of a party opponent may be admitted for purposes. One minute. May be admitted for purposes other than impeachment. Relative to back pay, if you find plaintiff is entitled to back pay, the plaintiff is entitled to back pay, which is the amount of the plaintiff's lost earnings from the date of the adverse employment decision until today. For purposes of this case, I'm adding relative to Mr. Dodge. If Mr. Dodge reasonably believed that the conduct violated General Laws Chapter 151B, the Anti-Discrimination Statute, or General Laws Chapter 31, the Civil Service Statute. You will have, once again, 4 copies of the jury charge with you, along with the special jury verdict slip, as well as all the exhibits. Ladies and gentlemen, we've taken care to order lunch for you. I hope you do not mind. We request that you deliberate through your lunch break. So with that, you may retire for your verdict. Thank you. I'll be making those corrections. I'll be back in. You will check the corrections, and then we'll mark the jury charge for identification purposes. We have other cases that are coming in at 2 o'clock, so I'll ask you to be so kind as to clear out your paperwork and brief.
Thank you.
Don't we have to check the exhibits?
There's just one that
I
remains.
understood you already had. Have you already checked all the exhibits?
Yes, Your Honor.
I think it has to go on the record.
Well, I was going to do them. I was going to come back, but if you haven't had a chance to check them all, please.
Rise, please.
Okay. Let's call our civil matter.
First back session, we'll see.
Back before the court, it's a matter on for trial, 1780 CV 0033, Patrick Buchanan et al. Versus the town of Greenfield et al.
Okay, first, any further typographical changes or anything of that sort to the jury charge?
No, Your Honor.
No, Your Honor.
Attorney Kessin?
Nothing that you've said.
Okay, so that'll be marked as D for ID. And here you go. If we could have 4 copies of that made and sent into the jury room. And I made the correction to the special jury verdict, including the yes or the no, so that takes care of that. The exhibits now. Have counsel now had an opportunity to review them?
Yes, Your Honor.
Are you satisfied?
Yes, Your Honor.
Yes, Your Honor.
Attorney Kessin?
Yes, we are.
Okay, Attorney Brody, very good. Okay, very well. We go until 4:15 or so. I've got a couple of other matters in the courtroom, so I do appreciate your All right. Welcome back, everybody.
Back in session, maybe seated.
All right, ladies and gentlemen, I passed to you a note, if I could see that for a brief moment, please, which was marked as E for ID, inquiring whether or not you wish to suspend your deliberations at this time and return tomorrow morning at 9 a.m. or continue to 4:15, and you have answered that you wish to suspend. And so, indeed, that is what we're going to do with the ongoing instruction, which I emphasize at this point, since you are now in the middle of your deliberations, not to discuss this case with anyone, not to discuss your deliberations with anyone, not to discuss anything having to do with any of the individuals, the subject matter, anything to do with this case, nor to do any investigation or research or look at any media reports. I look forward to greeting you at 9 a.m. tomorrow, at which point you will resume your deliberations. Thank you much and have a great evening.
Hey, Melissa. Melissa. They can take these. Okay.